This case cannot be heard on such and such a date because my senior counsel is not available. They get told, there are hundreds of lawyers in South Africa. If your senior counsel is on holiday, tough luck. You can go and get another one. The same applies here. If Mr. Downer, if someone else prosecutes the main criminal case against Mr. Zuma, there is no reason on earth why that criminal prosecution cannot continue and the private prosecution of Mr. Downer continues. So you have to create this bogeyman of the indispensable Superman, Mr. Downer, whose existence, and that's why we ask the question, and it's not out of respect or insensitivity, but we say the rhetorical question, what would happen if Mr. Downer is hit by the proverbial bus or nature takes its course in other ways? Does that mean that the prosecution of Mr. Zuma would suddenly disappear? No, of course not. That would be ridiculous. The private prosecution of Mr. Zuma is not dependent on anything to do with the so-called private prosecution, unless you believe in this Downer indispensability theory. So what I'm saying, Justice Ponan, is this, and again, I'm now covering both what Madam Justice President raised and which is the first element, exceptionality. I'm saying to the extent that that exceptionality is itself premised on the so-called abuse of process finding, it is fallacious, it fails both the standard of section 18.1, section 18.4 Roman 1, which says that that court must give you reasons, proper reasons. And by the way, that also touches on another issue, which is the agency issue. The reason that this court gave what, with respect, I can only call a half-baked judgment, which actually says things. It says, for example, we did not dispute irreparable harm. How can we did that in 20 pages, which I can demonstrate. The reason why it was done is because it was rushed, because it's supposed to be urgent. For what? If the court had taken its time and actually carefully considered the papers, it wouldn't have fallen into that trap. So, sorry.
Is it open to us in this court to interrogate the finding in respect of agency?
No.
Or isn't it that, well, wrongly or rightly?
It is what it is.
Yes,
Yeah.
Should we be debating agency here?
No. No, nobody's debating agency justice. I'm simply saying, I'm raising a different point. If you look at our heads, look at the preamble to our heads. The preamble to our heads deals with, I think it's paragraph 28 of the Free State case. And it says the following. I'm showing you the flaws in this judgment start from even the quality of the judgment itself. It cannot be sustained. That quotation says, it is trite that furnishing of reasons, remember here it's statutorily ordained, for a judgment is an indispensable part of the judicial procedure. Failure to furnish proper reasons amounts to a grave lapse of duty and a serious impediment to the appeal process here. Not only did the full court shirk this duty, but it also failed to consider any of the judgments of the various divisions of the High Court, you may add, and the SCA now, dealing with the applications under Section 18 of the Act, which had all been delivered prior to the full court handing down its order in terms of the reasons on 12 September, which is irrelevant. The point I'm making, Justice President, is not about agency. I'm saying the reason why the judgment failed the 18.4 Roman 1 test is because it was rushed for no apparent reasons, as we've had in the debate with Justice Ponan. As the result of that is that the appeal process, which is where we are now, is hamstrung by the fact that this judgment, I don't know how to put it politely, fails to deal with the arguments we made. Remember what Justice Binsward, and that has been affirmed in this court as well, I think in Klameza, says, which is that when this court considers, not this court, well, both courts, it considers the application, because it's a motion proceedings, it must take the version of the respondent. This court failed to do that. So it fails to just apply a simple rule, plus con events. The other side says it's an abuse of court because of Stalingrad, 20 years, and so on and so on and so on. We answer blow by blow, demonstrating that those are fallacious grounds. And the court just ignores it.
So your submission on the relation to the agency issue is because the court wrongly considered the matter to be urgent, that impacted on its reasoning.
Yes, in other words, my issue is not so much the agency issue. My issue is that this court is now settled with a judgment which simply does not address even the most basic rule of law, which is plus con events. Because to say, as this court says in paragraph 25 of its judgment, I mean, this is all that is said about exceptional circumstances. At 25, in response, the first respondent avers that the only exceptional circumstances is that all are not equal before the law. I don't even remember saying that. The first respondents contend that whenever he challenges the constitutionality of his prosecution, or the prosecutor's title to prosecute, it is labeled Stalingrad. However, when the applicant do exactly the same, it is labeled an exercise of constitutional rights. Yes, so we said that in the context of what's good for the goose is good for the gander. But that's not even the point I'm debating. I'm saying if this is all the reasons given to this court about exceptionality, then God save us all. Because we had gone, the treatise that I just gave you about the so-called 3 myths, we went blow by blow dealing with that. Nobody says we are wrong. Nobody says 20 years is 5 years. We are wrong or we can't calculate. Nobody says Stalingrad is real, even despite the fact that all judges never said it is. Nobody says Mr. Downer is actually indispensable. And we must be told if he is. Maybe he is. No one engages with what we say. That's an abrogation of plus con events. And then you get, this is all you get, which means nothing, absolutely. How can this court, as a court of appeal, be even able to say, yes, that court scrutinized the things we put, when they are nowhere to be found? And then it says at paragraph 29, I'm sorry, yes, Justice Bata.
Otherwise, we'll be running too fast.
Yes, sorry.
Because it ties up with what both Simon and Conan were saying. I want to appreciate this, and it's part of your argument, that there are cases, the KZN cases,
Right.
outer case, which says prospects of success are, they don't pronounce.
May not, yes.
much of them.
Yes.
But you are saying there are judgments of this court that say, particularly, the 2021 one that says, this is just not, for the courts to exercise the discretion whether to consider them or not. They are important
Absolutely.
for you to come to a just decision to say whether Section 83 has been complied or not.
Yes.
But you are also saying this court needs to stay so pertinently to give guidance to say if KZN is a bit uncertain, Gauteng is a bit uncertain, but Kunuk didn't say on these facts this should be prospect of success, even if not mentioned in Section 18 specifically.
Thank you. Thank you so much, Justice. But
I just wanted to so that I've been like.
no, thank you. Well, yeah, thank you. You brought me back where I wanted to be. I was just responded.
Yes, but I also want to take you to what you were quoting on paragraph 30 of Mila.
Right.
Because you left that as that one sentence that says this is despite the fact that the prospect of success is not specifically mentioned in section
Absolutely.
itself.
Thank you. That's with the greatest respect, Justice Mata. I only deviated because the President asked me to leave that point. So thank you for bringing that. Actually, to be honest, I mean Justice Machumi. Sorry, Justice. This case, to be honest, Justice Machumi, is about what you have raised. And that is it. Because unless somebody can show us that Bila and Justice Alliance and Ntlameza and UFS and GNOB are all wrong on this, then you cannot succeed in the SCA or on any appeal without having established prospects of success, without even pleading them. Forget about establishing. You can't. Why? Because and as Justice Machumi, as you put it correctly, the court in Bila says that this is a fourth element, even though it is not mentioned in Section 18.3. But it goes to, let me do this. Two fallacies about this, and I'm glad to have an opportunity so that my learned friends can address this. Most people think that the judgment in Ntlameza and AfriForum, because in those cases, both courts said, because the record is not in front of us, we're not going to deal with prospects of success. That is always, and always have to tell this to students, that's a mistake of not being able to distinguish between 18.3 application and an 18.4 appeal. In an 18.4 appeal, it is theoretically possible to deal with that appeal without determining the issue of prospects of success. Why? Because the court will not have the record, as it didn't have the record in Ntlameza, as it did not have the record in UFS. But in a Section 18.3 application, it is impossible not to have to deal with prospects. You can't do it. You can't just pick and choose which requirements you're going to determine. So it's fatal, and that's the word that is used in Bila. The omission to deal with that is fatal to the entire appeal. Or rather, it's fatal to the case, so the appeal must succeed on that basis.
Mr. Mpofu, are you integrating the requirement of raising prospects of success as a statutory requirement?
No.
But it's not mentioned in section.
Yes, that's exactly what the justice has said. The court said in Bila, although it is not mentioned in 18.3, it is a requirement of the law. And let me explain why that is so, Justice Salduka. Remember, I kept on saying you must, the word remain, you must emphasize. The fallacy is this. The question really is this. Did the introduction of Section 18.3 do away with the common law requirements? That's the real legal question. As Justice Sutherland found in that case. Because Justice Sutherland said, yes, now that we have Section 18.3, prospects of success. In other words, the introduction of 18.3 has now done away with that requirement, right? Then came the Justice Alliance judgment, which said, no, that's wrong. That element, the element of prospects of success, which was in the common law, remains. In other words, it's... But absolutely, that's it. That's the end of the case. If you, as I say, Justice Salduka, as you know, that's why I made the example of murder. If you don't plead one of the elements or prove them, how can you win? I don't understand. If we accept that this is a requirement, one. Number two, we also accept what is said in Bila for obvious reasons that the onus, not only is it a requirement, but the onus is on the other side. It must be, because it's part of the higher onus. How do you discharge an onus which you don't deal with in your papers? It's impossible. We all know the law has been repeated many times that you must make your case in your founding affidavit. Just like you can't put one of the requirements of interdict, just sneak them in the reply. You have to plead it in the founding affidavit. So it's fatal. Now,
Of
no.
because my don't get to those cases.
That is true.
Meaning, if we are with you,
On accept.
that those were not established, we don't have to deal with.
Absolutely. No, that's exactly.
Is that correct?
That's 100% correct, Justice. You remember when I talked about the so-called three legs, I said that the so-called third leg will only arise if I'm wrong on the exceptional circumstances, irreparable harm, and all that. You're 100% right. No, put it beyond doubt that effectively this is how it works. The court starts, as you correctly put Justice President. The court will forget about the points in limine and what have you. The court would look at the statutory requirements that are not controversial. And if it finds that there's no exceptionality, or there is irreparable harm to Mr. Zuma, for example, then that's the end of it. It has no discretion to exercise. Remember, the element of prospects of success arises in the form of a discretion. So it has no discretion to exercise, so you're quite right.
So if the statutory requirements have not been met, we don't get to discretion.
Yes, but I've made...
And we don't get to prospects of success.
Yes, except for the following context, which is what Justice Salduka was raising. Except if you look at it through the lens of what I call a point in limine. In other words, is the non-pleading and the non-establishment of one of the four elements, you'll work with me, when I say four elements, I know that's disputed, but for now, assume that I'm correct. Is the non-pleading of any one of the four elements fatal? The answer has to be yes. Then that's the end of it. Then you don't even have to, if you look at it, so you can do it either way. You can either look at it from that point of view and say, the non-bleeding of one of the four elements is fatal, goodbye, as was done in Bila. Or you could take the approach that is being suggested. It's the longer approach. I would say I wouldn't recommend it myself. But then you would have to go to exceptional circumstances, irreparable harm, and then after that you say, oh, by the way, there's also no pleading of the prospects of success. That wouldn't be the most prudent way to do it, but it can be done both ways. With the greatest respect, we would commend the approach suggested, implied, I don't want to put words in the Justice's mouth, but implied in the question from Justice Muchumi, which is that the starting point, there are two starting points. Is it a requirement? Yes. If it is, on who does the onus lie? And did that onus bearing party discharge the onus? Yes or no? That's it. And,
so before the extraordinary relief contained in Section 18 can be granted, you have to establish.
Absolutely. And Justice Saltuka, that's actually those words that you've just said are almost a mirror image of what Justice Binsward said. And this is another point that gets missed, that this is not just about prospects of success in the air. It's part of the exceptionality of this remedy, and that's a crucial point. If the court can allow me just one indulgence to explain this properly. One has to go. Everyone just talks about Justice Alliance, but nobody actually looks at it. In Justice Alliance, at paragraph 27, which has been affirmed 100 times in this court, well, I'm exaggerating, but in every case that has come before this court, 100%, I think it will be better. Yeah. It has been affirmed 100% in this court. It says at paragraph 27, and you'll remember, incubator is the Sutherland J case. This is what Justice said, and I'm going to read this because it's so important. It says, differing in this respect from the approach propounded in incubator holdings, I consider, in other words, differing from this thing that says prospects are no longer important, I consider consistently with the view expressed by Corbett J.A., very important, in South Cape Corporation, at 545E, that the court's assessment of the prospects of success in the appeal, factor 3, underline that, factor 3. I'll explain what factor 3 means. Factor 3 in South Cape Corporation remains a relevant factor in the consideration. Indeed, counsel on both sides in the current matter were in agreement with that proposition. I hope the history will repeat itself. It follows that the less sanguine or confident a court seized of an application in terms of Section 18.3 is about the prospects of the judgment at first instance being upheld on appeal, the less inclined it will be to grant exceptional remedy, the point that Justice Salduka has just made. The less inclined it will be to grant the exceptional remedy of execution of that judgment pending the appeal. Now here, it says the same quite obviously applies in respect of a court dealing with an appeal against an order granted in terms of Section 18.3. And this is where the confusion always lies. When the court says this, it means that, this is obviously with the benefit of hindsight. You can add there that in certain situations, this is now about the appeal court, where the record is available. That's what this court has just declared. That as far as the appeal is concerned, if the record is not available, you can still go ahead. But here's the most important part. It says, the position is very much akin to that which pertains when interim interdictory relief pending a judicial review is being considered. There's the giveaway. The position is very much akin to that which pertains when an interim interdictory relief pending a judicial review is considered. In other words, there is an onus, as is with the interdictory relief, and that onus is on the party that seeks the relief. But let's see what factor 3 is being affirmed here, because everyone just talks about prospects of success glibly. But if you go to, you can use that in, you use the same judgment of Justice Alliance, where it quotes South Cape. This is factor 3. You remember before, these were the 4 factors that we all grew up on. 1, the potentiality of irreparable harm or prejudice. 2, I'm cutting some words. 2, the potentiality of irreparable harm or prejudice being sustained by the respondent. And 3, this is factor 3. Let me read it out slowly so that it can be dealt with, hopefully, by my learned friends. Say, the prospects of success on appeal, including, more particularly, the question as to whether the appeal is frivolous or vexatious or has been noted not with the bona fide intention of seeking to reverse the judgment, but for some indirect purpose, e.g. to gain a time or to harass the other party. In other words, factor 3, which was being affirmed, you have to prove 2 things if you are the onus-bearing party. 1, you must show that there are good or bad prospects of success, but also show that the appeal itself now, what Justice Bonan correctly calls the main appeal, you must then say that appeal, you have a burden to show that appeal is malafide. In other words, Mr. Zuma is not really aggrieved by all those things listed in the application for leave to appeal. He's just playing with the court. Where in these papers do they even attempt to do that?
Is it not sufficient that they appeal that reasonable prospects of success? And is it not relevant for the present debate that, in fact, as far as the main judgment is concerned, an application for leave to appeal has already been dismissed?
No. Yes, okay, thanks. One of my juniors asked that question. No, it's not. And the reason is very simple. Just as, if you remember, we were wrongly accused in the judgment, by the way, of having objected to the application, or to the Section 18 application being lodged before the application for leave to appeal. We didn't do such thing. It would be ridiculous to do that. All we said was that because you have not seen the application for leave to appeal, it does not lie in your mouth to say that it has no prospects of success. Because you don't know. What if, as it happened, there were 12 points, I just counted them this morning, 12 points that are raised there. So that's the answer to that. So in the same way, Justice Ponen, again is the judicial intervention. Remember, at face value, it might look that way. That how could you even bring a Section 18 application when there's no application for leave to appeal? But the court have said, no, you can do that. Because if you can anticipate that there is indeed an appeal coming, then you are free to do that. In the same breath, here, if you look at paragraph 16.3 of my learned friend Mr. Badlander's heads of argument, he says that it is anticipated that there'll be an appeal. Otherwise, we would be wasting your time here. And as we said earlier, Justice Ponen. And that appeal obviously will come in due course when the 30 days or whatever the period is. But it has already been indicated and is accepted by everyone else. So it goes back to what you raised earlier, Justice Ponen, which is that the fate of that petition, actually, that's what it will be. The fate of the petition lies elsewhere. It will be dealt with by 2 judges in the normal way. It might go to the Constitutional Court. Nobody knows. And that's, by the way, is one of the reasons why in KNUOP, the discussion of this issue of prospects of success, Wallace J.A. goes as far as to say, remember that even when there are no prospects of success, the appeal may still succeed. Because as we all know, the appeal may succeed on the basis of Section 17A1A Roman 2, which is that there are exceptional circumstances, there are other grounds upon which the appeal should be held. So that's why Justice Wallace says that even if, when you look at it, you may say, these prospects are weak. Remember that prospects of success on their own are not the only gatekeeping mechanism. So the answer is the dismissal of that application for leave to appeal has no bearing whatsoever. And rightfully, my learned friends have not raised that point because it would be quite frivolous. Yeah.
But I do have a question.
Thank you.
You submitted that in relation to Mr. Downer, there was no allusion whatsoever to process of success.
Yes.
That was not pleaded in relation to Mr. Downer.
It's mentioned somewhere.
What is the criticism in relation to how she has dealt with it? Because there is reference.
Yes. But yes, thank you, Justice. Justice President. Surely, if a court is examining whether, let's say, you have passed the threshold for establishing irreparable harm, it can't say you mentioned it in your affidavit, and therefore you have discharged the owners. You must discharge the actual owners. So mentioning it in the context of saying, remember, Justice, that in any event, even if they had actually done more than mentioning it, it would have been a shot in the dark. Because they did not, unless if they are sangomas of some sort, then they would have said, okay, we know what your application for leave to appeal is going to say. We know that even if you're going to raise 100 grounds, all of them are going to be frivolous. Not only that, according to so-called Factor 3, those grounds will also be malafide. How? So, if you like, the discharge of that onus, mere mentioning and moving the lips and saying prospects of success on appeal, cannot amount to discharging an onus. And nochal, the heavy onus that we're dealing with here, which is a superlative, a higher onus than normal. So, and it is in that context, Justice Miller, and I really have to emphasize this point. Let me add to that. Now, you can say, okay, we forgive you for not dealing in substance with the prospects of success in the founding papers. That should not be forgiven, but let's be kind. You say we forgive you for that because, why do we forgive you? Because at that stage, you had not seen the application for leave to appeal. Right. What do we do? In the answering affidavit to Ms. Maughan, we then attach the application for leave to appeal, which is an invitation now to say, okay, maybe we'll overlook the fact that you might want to deal with it in reply. But here it is, here are the grounds. In reply, which you will find at page 490, she doesn't take the invitation. Nowhere, even in reply, do they say, okay, we had this handicap in chief where we did not deal with prospects of success, but now that handicap has been cured, and we now have an application for leave to appeal. But it's nonsense. Nothing. They don't even do that. We would be debating a different thing now about whether you can do that in reply and so on. They don't do it. So how on earth could anybody, any court, find that they've discharged the heavy onus on prospects of success? It's impossible, Justice Muluma. It really isn't. You can't discharge an onus. This thing called an onus means literally a burden. It's a burden on your shoulders, which you must overcome.
It's to me, though, that in respect of prospects of success, she has also taken into account and relies on the finding of the court that there was an abuse of process.
Yes, but that's a non-argument with respect. That's what I was. You can't say you lost because you've lost. You can't say no. So you can, but you shouldn't. In other words, what do I mean by that? What I mean by that is that Justice Muluma, Madam Justice President, if we all understand that the purpose of Section 18 is effectively to protect the losing party from the judgment which is adverse to it. It's already adverse. So you can make it more adverse by saying, okay, in now doing the Section 18, we're going to look at the adverse judgment. Then no losing party will ever win a Section 18 application. Because every time we'll say, no, but look at the judgment, you lost. You can't. This court and that court had a duty in terms of ACJ, as it then was, to scrutinize the abuse allegation and see if it holds any water. If it holds water, as I say, then we must lose. If it doesn't hold water, as I've amply demonstrated, based on the three myths upon which it is premised, then you can't. You can't. That's why we call it in our heads lifting. That court was lifting itself by its own bootstraps, because what it is saying is that because we found abuse against you, then we're going to use that finding to now find against you in the 18.3. It does not work. It can't work like that, because if it did, no one would ever succeed. No. Oh, sorry, Justice. If you maybe finish. Okay. Yes. Yeah. yes. Sorry, I'm sorry. I didn't mean to interrupt. This is the thing, Justice. This is a deeply philosophical issue, and I'm sorry to sound like a broken record. You have to start as your starting point from the fact, why do we have Section 18 in the first place? It is there because it wants to, and in honesty, at least to give credit where it's due. I think it's my learned friend, Mr. Badlander, whether in his heads or in the affidavit, I'll deal with it in reply. But they say that when they put the so-called harm, they say if the judgment is suspended, then it will take away the operationality and the executability, and they say, which means the effect of the judgment. And they are right. We agree. Because the purpose of Section 18 is to take away the effect of the judgment and suspend. Suspend in the Oxford Dictionary means that to put the force and effect of something in abeyance. So you can then go and fetch it from that dustbin of abeyance and say, I'm now going to use the very same judgment. That's why I was saying when I answered this question earlier, there's the reason for Section 18.4. Because Section 18.4 is meant to protect us from this very question. Because every time we come here, we would be told, no, but look at this. But 18.4 says, no, that is suspended, apart from the fact that it was already suspended in 18.1, right? So that's why I'm saying the court cannot lift itself by its own bootstraps. Because why? Because the whole purpose of this thing is that one day this court or the Constitutional Court may find that there's no abuse of process. That's the whole purpose of why we're here. We're here to protect that idea, to protect the idea that one day a court will find that there's no abuse of process. So if we want to subvert the entire exercise of Section 18, then we must do what is being suggested and say, no, let's work on the basis that the appeal will be overturned, both on here. Imagine, in fact, let's look at it in terms of the real law. Imagine the irreparable harm that would be caused to Mr. Zuma if not even this court, ultimately the Constitutional Court says there was no abuse of court. That's what Section 18 is there for. Because then he would have gone through all this trauma, all these adverse impacts. For what? For something that's non-existent. For something that the Constitutional Court or this court will find was spurious, based on false premises, as I've demonstrated. Imagine that. That's what Section 18 is supposed to be. You can't imagine the other way. Because if you're saying, I'm going to imagine that the abuse will be upheld, then you are favoring the winning party, which is, I don't even know what to call it. It's a catastrophe. Section 18 was meant to exactly stop that. You can't favor the winning party in the assessment of these questions. You have to favor the losing party because I'm sorry. Yes. Okay. Okay. Yes.
May I kindly request you to wrap up in 5 minutes?
Yes.
Then we take the tea agenda.
Thank you very much. Just okay. Sorry. Yes, I can say the 5 minutes. Right. Okay. So let's wrap it up like this. As I've said, it doesn't matter which way you look at it. You can start with the 3 requirements, or you can start with the prospects of success. Our humble submission is that this court should take the approach that was taken in Bila. And the retort by the other side, where it says, but Bila was decided before Knob, is like saying nothing. Because it doesn't matter whether Bila was decided before Knob. It would only matter if Knob departed from the position taken by this court in Tlameza and Free State. And nobody, I don't think in their right mind, will say that Knob did any such thing. So the position in Knob, in Tlameza, in UFS, and in Bila is consistent with this idea of retaining the common law element. Think about it like this, Justices. There are 2 types of legislative intervention that can be made. The legislature might say, here's the common law position. We don't like it. It's bad. It's oppressive. It's not consistent with our constitution. And we are changing it. Holus bolus. Or the legislature might say, as it did here, here's the common law position. We like it, but we don't think it's sufficient. We want to add on to it. That's what Justice So the word remain means that. So Section 18 could not have done away with the requirement of prospects of success, which was already there, because the court was not breaking, it was building on top. So that base, it remains there. Prospects of success is there, and then you add all these other 7 things. Number 1. Number 2, the onus has to be on the onus bearing party for the reasons explained by Justice Salduka, which is that this whole debate is part of the exceptional remedy in the first place. So it's adding yet another hurdle, if you like, for the winning party. So it's impossible. I'll go as far as that, and that's my last submission. It's impossible for these parties to. It was impossible to have succeeded in the Kotako, and it's impossible for that same reason that they can succeed here. And this appeal should be approached in the same way as the Bila approach, because the Bila approach is correct. It's based on the judgments of this court. It's based on the Preferable Justice Alliance approach, and it is commendable. And if you just give me 1 minute, Justice, so that I can refer to the reason why I attached to this document the latest judgment, which is a judgment of Mushwana. That's the UNET, RAF versus UNET. It's Mushwana J, Malungana AJ, and Skosana AJ. I just want, I don't have time now to build it, but I would recommend. This judgment is probably one of the best expositions of why we have Section 18, because it starts, as I said earlier, with the issue of NSCJ, and it uses words like unseat. It says if you want to unseat the default position, then you must do this, you must do this. If you want to unsettle, so in other words, the starting point must always be when somebody puts an application for leave to appeal or intends to appeal, that judgment is suspended. Unless there are exceptional circumstances, there's irreparable harm, what have you. So the starting point is, you must read Section 18.1, starting from the words, from the default position. If someone is intending to appeal, they must be protected by the suspension of that judgment. Full stop. But of course, as everything in law, there are all exceptional circumstances which might make you to deviate. The question here is, has anything been said here to deviate from the default position? The answer is no, on the 3 statutory requirements alone. And the answer is now a big no, if you also consider that the 4th requirement has not even been pleaded. As the court, please.
as the court pleases. I've heard the debate. That's just been very helpful. Thank you. Yes, I did. Thank you very much. I hope not. The full court has held that the private prosecution of Mr. Downer is an abuse of the process of court and has ordered that the summons is set aside. Mr. Zuma is attempting to appeal against that order. The High Court has refused to grant him leave to appeal. One assumes that this court will be his next port of call, and if he fails, he will then try the Constitutional Court. So the matters which I'm going to address are the following. Firstly, what this case is about and not about. Secondly, exceptional circumstances. Thirdly, abuse. Fourthly, that the abuse, yes. Fifthly, harm to Mr. Downer. Sixthly, harm to Mr. Zuma. Seventhly, prospects of success. I'm sorry. It's after harm to Mr. Downer. Do you have that, Madam President? Let me take it from the beginning. Firstly, what the case is about. Then secondly, exceptional circumstances. Thirdly, abuse. Fourthly, harm to Mr. Downer. Fifthly, harm to Mr. Zuma. Sixthly, prospects of success. I'm sorry. In preparing for this hearing, I started by reading the founding affidavit and Mr. Zuma's answering affidavit. And four things struck me on reading the answering affidavit. The first thing was that it was an extraordinary torrent of abuse and insult directed at Mr. Downer. I've literally never seen anything like it before in court papers. Secondly, and more importantly, the reason for this became clear. It became clear that what Mr. Zuma thought the Section 18.3 application was about whether Mr. Downer should be permitted to prosecute him. He thought that was the issue in the case. And can I show the court why I say that? It's at page 113 of the record. Paragraph 132. Dealing with prejudice. Page 113, paragraph 132. This is what Mr. Zuma says. There is significant constitutional prejudice that I will suffer if an order is given by the full court giving Mr. Downer the right to prosecute me, pending my appeal against the judgment and order of the full court. Now, that was not an issue in the Section 18.3 application. It's not an issue in this application, but Mr. Zuma seems to have been advised that it was, and his affidavit said that's his prejudice. That's what he thought the Section 18.3 application was going to decide, whether Mr. Downer was allowed to prosecute him. Thirdly, consistently with this understanding, in his answering affidavit, Mr. Zuma barely addressed the issue of whether an implementation order should be granted. The focus was why Mr. Downer is a very bad person and shouldn't be allowed to prosecute him. And fourthly, the other thing that struck me in reading the heads of argument, the answering affidavit, is that all of Mr. Zuma's criticisms of Mr. Downer had previously been raised in the Section 106(1)H special plea, and all of them had been rejected by Mr. Justice Kuhn. Justice Kuhn carefully analyzed the facts of every one of those complaints about Mr. Downer, and he found that every one of them, on the facts, was unfounded. And you'll find them from, I hope the court will be able to find the judgment If it can't be found, we'll make a copy available. You'll find them from paragraph 172 to paragraph 268 of the judgment of Justice Kuhn on the 26th of October 2021. That's the 106.1H judgment. 100 paragraphs he devoted to addressing the complaints about Mr. Downer's conduct, and he rejected every one of them. He found all of them were unfounded. And then, I'm not going to take the court through all of those, it would be tedious. But can I just take the court to one of them, because it's one on which, it's an issue on which Mr. Zuma places a lot of reliance, the whole complaint about the spy tapes, about spying within the NPA, and about political abuse of political decisions whether to prosecute, and the improper intrusion of political decisions. And that's what the spy tapes litigation was about, which ran for 7 or 8 years. And let me just read to the court what Justice Kuhn said about that and Mr. Downer's role. He said, firstly, paragraph 215, he found that a lot of the submissions made by Mr. Zuma were incorrect. He said, these are matters of public record. He says, let me read it. He says, Mr. Downer was not an essential witness in the spy tapes case, as alleged by Mr. Zuma. He did not submit his affidavit in support of the DA, as alleged by Mr. Zuma. His affidavit was provided at the request of Mr. Hofmeyer of the NPA, after he, Mr. Downer, had refused to make an affidavit simply confirming the contents of Mr. Hofmeyer's affidavit. And Mr. Hofmeyer, of course, was at the heart of all the political maneuvering. The initial draft of Mr. Downer's affidavit was in fact revised by counsel for the NPA, Advocate Millard. Mr. Downer's affidavit disagreed with the decision of Mr. disagreed with the decision of Messrs. Mshe, Hofmeyer, and the senior leadership of the NPA, who had sought just to defend Mr. Mshe's decision to discontinue the prosecution. These are matters of public record about which there is no dispute. Mr. Downer's independence of mind speaks for itself. And his stance was ultimately vindicated by the judgment in the spy tapes matter by the SCA, after both Mr. Zuma's counsel and counsel for the NPA conceded that Mr. Mshe's decision, which they initially sought to defend, was irrational and unlawful. And that's the one which goes to the heart of Mr. Zuma's complaints about Mr. Downer. I'm not going to go through the rest, but if you go to that judgment of Justice Kuhn, you'll see each of the complaints is rejected as unfounded. As the court knows, Mr. Zuma attempted to appeal against that judgment and order of Justice Kuhn. Justice Kuhn refused leave to appeal. He then applied to this court, and this court refused leave to appeal. He then applied to the president of this court for reconsideration, and the president refused reconsideration. He then applied to the Constitutional Court for leave to appeal and eventually abandoned that application, I think. So the judgment of Justice Kuhn stands. Its findings on all these issues which Mr. Zuma wants to rehash in this case and in his answering affidavit in this case about what a terrible person Mr. Downer is. The judgment of Justice Kuhn stands, and Mr. Zuma's onslaught of abuse and insult is simply unfounded. Of course, what we know another thing about the background to this, which is that the courts have already rejected one attempt to have Mr. Downer removed. That was in the section 106.1H plea, which was the subject of successive attempts to appeal, failed attempts to appeal. So the courts have already once found in that case, rejected an attempt to have Mr. Downer removed. Now Mr. Zuma has made a second attempt to have Mr. Downer removed. It is currently pending before TLJ and will be heard next month. And that's where a decision will be made as to whether Mr. Downer is a suitable person to prosecute. The attack on Mr. Downer is irrelevant to the matter before this court. I make only the following further observations about Mr. Zuma's desire to have Mr. Downer removed. First, this is the reason for the private prosecution. The reason for the private prosecution is to get rid of Mr. Downer as his prosecutor. That's an ulterior purpose. You're entitled to authorize to institute private prosecutions in order to get your alleged offender prosecuted and convicted and punished. That's not what he's really looking for. He wants to get rid of Mr. Dana. And if a power is exercised for an ulterior purpose, the courts will stop the private prosecution, and that has been our law at least since 1950, when the Solomon case was decided. It's been confirmed by this court, and it's been confirmed recently by 2 full courts in Gauteng. So that's the reason, getting rid of Mr. Dana. Secondly, Mr. Dana believes that he is entitled to obstruct and delay his prosecution unless Mr. Dana is removed. And this is what he says. Can I take the court to what he says on the record? It's firstly page 75 of the record, volume 1. Got the wrong yes, it's paragraph 23 on page 75 at the foot of that page. And this is what, 3 lines from the foot of the page. This is what Mr. Zuma says his attitude is. He says, "The day a professional prosecutor is assigned to my case, I will gladly stand trial and prove my innocence." In other words, I'm not going to stand trial. I refuse to stand trial while Dana is there. And then, if there were any doubt about that, the same theme is taken up at page 97, paragraph 83, at the 3rd line. This is what he says: "I have always stated that I will yield to a fair and impartial prosecution and not a kangaroo trial, which it would be if Mr. Dana, who is dripping with violations of my constitutional rights, is permitted to prosecute me. I will not allow my rights to be violated by a prosecutor whose determination to prosecute me appears to be designed to nurse an insatiable ego." So Mr. Zuma's position is quite clear. He won't stand trial.
Sorry, my record has 2 different page numbers.
Yes. I'm referring to the larger page number, the top right.
Okay, page 90.
Page 97. Yes. Para 83. Yeah. So that's Mr. Zuma's attitude to this prosecution. He won't go. He will stop it. He will obstruct it, and he will delay it. He will do anything that is necessary. He will not stand trial if Mr. Dana is there. But if this, Mr. Zuma appears to take the view that he has the right to have a designated prosecutor removed by instituting and pursuing a vexatious and unfounded private prosecution. We submit that Mr. Zuma is wrong. If his stratagem succeeds, this will become the basic tool in the toolbox of every well-founded accused who wishes to obstruct and delay their prosecution. They will lay a trumped-up charge, a trumped-up private prosecution, spin that out, and meanwhile that they will say, well, I can't be prosecuted by this person because he's facing charges, which is what Mr. Zuma says. The simple fact is that Mr. Zuma does not have the right to prescribe who may or may not prosecute him. That's the law for everyone. Then can I come on to the question of exceptional circumstances? We deal with this in paragraphs 45 to 55 of our heads of argument, and I'm not going to read out to the court what is there. The court will have read it. I make just a few points.
Can you just respond to the submission that, in the agreement, that any other prosecutor can deal with this matter? So it's not necessarily a delay detective, because any other prosecutor could proceed.
With respect, Madam President, that's not a call for Mr. Zuma to make. When have we heard of accused saying, no, I don't want this prosecutor, give me another one? It's true that he says another prosecutor could come, and another prosecutor could perhaps, or could in time, obviously, accumulate the knowledge which Mr. Dana has accumulated over the last 20 years, could read himself into it or herself into it, and learn it and study it and gradually catch up. But there would be a great disadvantage to the state if Mr. Dana were not able to prosecute. He's been building this case for a very long time. But yes, another prosecutor could be found, but it's not for Mr. Zuma to say another prosecutor must be found. So then I come to the question of exceptional circumstances. And we deal with this at paragraphs 45 to 55 of our heads. And the court dealt with exceptional circumstances. The court, dealt with exceptional circumstances in paragraphs 17 to 26 of its judgment. And the court, we point out the following on our heads of argument. Firstly, if the private prosecution continues while Mr. Zuma attempts to appeal against the order of the full court, that will negate the order of the full court. The order of the full court might as well be cancelled because the private prosecution will continue. And the result will be that Mr. Dana will forfeit the substantial relief which the High Court, which the full court ordered he should get. And that's one of the grounds. The incubator makes the point that that's one of the bases in which you grant interim relief of this kind, an implementation order. If not granting the implementation order, continuing suspension of the order means that you lose the very purpose of the application. And the circumstances are truly exceptional. It's a matter which has been running for 20 years. It has been going for 20 years because the first litigation in this case was in 2003 when Mr. Zuma brought an application to the High Court to try to get the famous encrypted fax. It started then. It didn't start when he was first charged. And then there was another application by Mr. Zuma in 2006 to try to stop mutual legal assistance being granted in Mauritius. So it goes back all this time. But the fundamental point is the point which is, with respect, made by Justice Ponnen. The private prosecution is an abuse. That's what's been found, and that finding stands until it's been set aside. And if the implementation order doesn't remain in place, the abuse will resume and continue. This is not an ordinary case in which the implementation order regulates the relations between the parties in the meantime while appeals are running. This is a case in...
This appeal is narrow, in a sense, isn't the appeal as narrow as that?
Yes. That's
what takes it out of the ordinary.
Yes.
That's why a lot of the authorities and a lot of the debates that we've been having about the factual issues and whether or not one can properly characterize this as Stalingrad,
yes.
All of that falls by the wayside.
Yes, because the question which the court ultimately has to answer, I submit, is whether it's all an interest of justice test at the end. Is it in the interest of justice that the abuse should continue while Mr. Zuma is attempting to appeal? And if the answer to that is no, then this appeal must fail. That's with respect, the end of the matter. And you can get to that route by various routes, Justice Ponnen. You might take the view that, in fact, the right of appeal in Section 18.4 is simple. All that means is that you don't have to seek leave to appeal, and you still have to show that this is an appealable decision. You might take the view that it covers both the right to approach the court and whether the decision is appealable. We, with respect, take the view that it's both, that it covers both whether you need leave and whether you can appeal that decision, whether the decision is appealable. But that factor that Justice Ponnen mentioned bears on a number of very important questions. Firstly, it bears on the question of harm. There's no harm caused, I'll come to harm to Mr. Zuma, but the harm caused to Mr. Dana is very substantial in that the abuse will continue. So it's relevant to harm. It's relevant to whether the decision sought will have a practical effect, raised by Justice Ponnen. It's relevant to a string of issues which come into the court's weighing of how to exercise its discretion. But we do submit that I have to confess immediately that I hadn't considered this point until Justice Ponnen raised it, as to what the consequences of the fact that it's a continuing abuse. It does seem to me that the right of appeal is both a right to appeal without getting leave and a right to appeal in respect of the particular matter. In other words, it makes the decision appealable. But I can see the contrary view.
Yeah, but does that necessarily address the nature of the order and whether or not properly scrutinized?
Yes.
The order in this case is final in effect. For example, a la Zweli, the three Zweli requirements. I think that's what I've been grappling with.
Yes.
In my mind.
Yes.
Because, yes, I mean, what the legislature has ordained effectively opens the door of this court to an appellant in the position of Mr. Zuma in this case.
Yes.
But once an appellant has entered the door and is before the court, well, does it then mean that a court doesn't scrutinize the nature of the order?
No, absolutely.
And does it mean then that the usual considerations that would apply with regards to the exercise of this court's appellate jurisdiction, is that all subsumed by the fact that the legislature has ordained an automatic appeal and that we've got to constitute ourselves as a matter of urgency? I mean, I think those are some of the things that I'm grappling with.
I appreciate that, Justice Pananath, and with respect, they're not easy questions.
Yes.
But one thing that is clear is that the court, when seized with this appeal, may consider and will consider the consequences of the appeal, the nature of the appeal, the nature of the order against which the appeal is sought, and the court may say, well, you're entitled to come to us without applying for leave, and you're entitled to require us to hear the application, but that doesn't mean we have to grant it. We may say this is futile, because it has no consequences besides stopping an abuse which is taking place at the moment, and that would be fully with respect within the jurisdiction of the court.
In each instance, if one looks at paragraph 1 of the order, that doesn't impose an obligation to do anything or to refrain from doing anything as far as the other legitimate
That's right.
to the list is concerned.
That's right.
And I think that's what, in a sense, differentiates what we are dealing with here from the usual kind of matter.
Very much so. And further, if Mr. Zuma's appeal ultimately succeeds, he can resume his private prosecution.
Yes.
He can carry on. So there's no harm. So that's all I wish to say in exceptional circumstances. Then I want to talk about abuse, and let me try not to be too long about this. There are three reasons why the private prosecution is an abuse. The first reason is that it is a continuation of the sustained attempt by Mr. Zuma to prevent or delay his trial taking place. And that's dealt with in the papers. I'm not going to take the court through all of that. Can I just refer this court to, not necessary for the court to go there, just give the court a reference to volume 2, page 293, paragraph 294, paragraph 45.3.2, where Mr. Dana points out, it's paragraph 45.3.2 in the replying affidavit, page 294, Mr. Dana points out that since Mr. Zuma and Talius first appeared in the High Court in April 2018, that's 5 years ago, there have been no less than 13 applications brought, including the present one. It's paragraph 45.3.2. 11 of these were instituted by Mr. Zuma, and 2 were the applications relating to the private prosecution. Mr. Zuma has been unsuccessful in all 11 of the applications brought by him. I include in this count both his substantive applications and his applications for leave to appeal subsequent thereto. So that's what's been going on just in the last 5.5 years. I forgot my timing right. In the last 5.5 years. The timing of the private prosecution is very significant, and I ask the court to have particular regard to it. What happened was that Mr. Zuma's application for a permanent stay was refused. His attempts to appeal against that order were all dismissed. Then his special plea, the Section 106(1)H plea, was also dismissed, and all his attempts to appeal against that order were rejected. And so the consequence was the stay was gone, the special plea was gone, and the trial was about to begin. Mr. Zuma was going to be required at last to plead to the merits of the case. And the prosecution witnesses were about to give evidence. To put it colloquially, Mr. Zuma had run out of road. The trial was now finally going to happen. And so what did he do? He did two things. Firstly, he instituted this private prosecution. And secondly, he brought a second application for the removal of Mr. Downer. So far, those two stratagems have achieved a delay of about a year. Because of the stratagems, the trial won't start this year. Depending on what happens in this case and in the case in the High Court, it may not even start next year either. So the abuse is continuing to succeed, although one has the sense that the day of reckoning may finally be approaching. Mr. Zuma is very offended by our reference in this context and by the full court's reference to a Stalingrad strategy. We use it in part because it was Mr. Zuma's counsel who announced that that was going to be the strategy, and Mr. Zuma has never distanced himself from it or explained that it means something different from what everyone understands by Stalingrad strategy. Mr. Kemp said, this is a Stalingrad defense. And so, but the term Stalingrad is very offensive. Let's just take that word away. Let's just call it a strategy of successive pre-trial interventions, each one pursued to its unsuccessful end, after which the next intervention is started. After that one reaches its end, the next one is started. All of this designed to obstruct and prevent and delay the criminal prosecution. That is what has been going on. During the entire period since 2003, Mr. Zuma has taken every opportunity to attempt to obstruct the collection of evidence against him, to attempt to have the prosecution stopped, and to delay the prosecution. That's 20 years of it. Mr. Zuma's counsel lays a great deal of stress on the fact that he didn't initiate the spy tapes litigation. That's true, and it ran for a number of years. It was an attempt by the DA to have the NDPP's decision to withdraw the prosecution reversed. So the consequence would be that the prosecution would restart. Mr. Zuma was an active and energetic participant in the Skytex litigation, in opposition to setting aside the decision of the NDPP, in other words, to avoid being prosecuted. He wasn't a passive bystander. He litigated actively in an attempt to prevent himself being prosecuted. And I've already referred to what happened in the last 5.5 years. Then I need to deal here with Mr. Zuma's repeated refrain that Justice Kuhn and Justice Steele, quote, roundly rejected, close quote, the Stalingrad narrative. Mr. Zuma goes so far as to say, under oath, that Justice Kuhn repeatedly rejected this fanciful false narrative. That's at paragraph 86, page 97. That's simply not true. Justice Kuhn has never rejected the Stalingrad narrative. What he had before him was he had an application by Mr. Zuma for a postponement of the trial. Mr. Zuma said, I want the trial postponed because I have applied for reconsideration to the president of the SCA and I want to await the outcome of that, and the trial shouldn't start until that has been decided. And what Justice Kuhn said was, well, it is said that Mr. Zuma engages in delaying tactics, but can I say that this application for a postponement, or rather that application for reconsideration, is an abuse? And he said on the facts before him he couldn't find it. He said, therefore, I must postpone the case because he's made an application for reconsideration. Ordinarily, you would postpone a matter while that is being dealt with, and I haven't got enough facts before me to say that was done in bad faith or was an abuse. One can understand that with respect. But now things have changed. Now things have changed, because now what we have is we have the private prosecution which has been instituted, which is an abuse. It's an undoubted abuse. And we also have the second application for the removal of Mr. Dana. The full court below, the court had every reason on the evidence before it, which is that whole history, plus what Mr. Zuma did when he ran out of road, 2 new stratagems, to conclude that the private prosecution is part of a deliberate and structured, decades-long strategy of obstruction and delay. And the assertion that J, quote, roundly rejected, close quote, the Stalingrad narrative is unexplained. There's no evidence before the court that he ever considered whether there was a Stalingrad strategy and rejected it, roundly or otherwise. You won't find that anywhere in the papers. We don't know what Mr. Zuma is talking about. The assertion by Mr. Zuma is a fiction. It is unsupported by any evidence, just like it is a fiction that Justice Kuhn repeatedly, roundly rejected the Stalingrad theory. There's another fact which needs to be brought, which I need to draw attention to in this case, in this context, and that is that our learned friends say, no court, all the judges who have considered these matters, none of them has ever said that this is Stalingrad strategy. Well, with respect, that's wrong. Can I give the court the reference? It's the Democratic Alliance versus the President of the RSA, and the reference is 2018 ZAGPPHC 836, also reported in the All South African reports. This is what a full bench of the Johannesburg court said in that case. They said, Mayor J with Ladwaba J, DJP and Kubushi J concurring found that Mr. Zuma had adopted a Stalingrad defense strategy in his criminal prosecution, and that this strategy had cost the state and hence the taxpayer thus far a total amount of between 16 million and 32 million rand. So there was a full bench decision that there was a Stalingrad strategy, and that decision of the full court in Gauteng was upheld by this court. In Zuma versus DA, in the funding matter, yes, that's the funding matter, that's correct. Yes. This court upheld the decision of the full bench. It didn't say, oh no, this is not Stalingrad. What does Stalingrad mean? So that's the first reason why this private prosecution is an abuse. It's part of a strategy of delay and obstruction because he's run out of road. The second reason why the private prosecution is an abuse is that the prosecution is entirely meritless. It is a trumped-up charge. The charges and complaints were considered in detail by Justice Kuhn. Those very complaints, and he held that they were without substance. Can I just give the court the references? I'm not going to take the court there, or to all of it. Firstly, the complaint about disclosure to Mr. Soul in 2008, if I have it correctly, I may be wrong on the date, but many years ago, suddenly exhumed as a charge. This is what Justice Kuhn said. He dealt with the matter paragraphs 231 to 237 of the 106.1H judgment. 231 to 237. 234, he said, at the hearing of the stay application, Mr. Zuma, through his counsel, expressly disavowed and accordingly waived reliance on the leaks. That includes the leak, the Soul leak. That this was so has not been disputed in reply. Mr. Masuku, who co-signed the special plea in this matter, is one of the senior counsel who represented Mr. Zuma in the stay of prosecution application. The alleged media leaks to Mr. Soul are accordingly at that level no longer an issue on which reliance can be placed. Then he goes on, he says, Mr. Downer admits to having had certain discussions with, paragraph 235, to have had certain discussions with Mr. Soul, Sam Soul of the Mail and Guardian, but denies that these were related to the investigation and prosecution of Mr. Zuma, except for 2 questions which related to the workings of the International Cooperation in Criminal Matters Act and international requests for mutual legal assistance. He denies that these involved any confidential information regarding Mr. Zuma's prosecution being disclosed. That version of Mr. Downer is not gainsaid. Paragraph 237. This is accordingly not a ground to find that Mr. Zuma doesn't have title to prosecute or that he should be removed as prosecutor. He had not disclosed anything confidential regarding Mr. Zuma to Mr. Sol. That's what the court found after looking at all the evidence. And then as far as the letter, the famous letter of Dr. Mduchwa, that's dealt with from paragraphs 246 to 266. I'm not going to take the court to all of those. Can I just refer to a few paragraphs? Paragraph 26, it's dealt with for several pages, analysed in detail as to what happened. At 263, the court says the only inference of a letter written by Mr. An affidavit signed by Dr. Mduchwa was that the intention was for it to be filed in court. The only inference is that the intention at that point was that the letter of 8 August 2021 would form part of the application for a postponement, pursuant to the terms of my directive, which would mean that it would become public when filed. That would be inconsistent with the protestations that the letter was a confidential document, of which the confidentiality, if in fact it was confidential in the first place, was not waived. The letter had furthermore been disclosed to Mr. Down and others at the NPA without any specific conclusions, restrictions as regards confidentiality. Paragraph 265, the letter of Brigadier General Mduchwa is vague and general in its terms, doesn't disclose any particularity which could be said to amount to a violation of Mr. Zuma's rights to privacy, doesn't mention the medical condition Mr. Zuma suffers from. I'm not persuaded that the disclosure of the contents constituted an actionable violation of Mr. Zuma's rights. So these things have been considered already by a court in a judgment which Mr. Zuma tried to appeal against and failed. Mr. Dana, we all know Mr. Dana didn't communicate the medical information to Ms. Maughan. It was Mr. Breitenbach who did that. Mr. Zuma says, but you're an accessory. You're an accessory after the fact of the commission of the offence by Breitenbach. But he doesn't say what it is that Mr. Dana did. What is the actus reus that makes him an accessory? And if I can just give the court the reference to Lawser, volume 11, third edition, paragraph 136. The court, the author explains what an accessory is. He says an accessory after the fact is a person who, by his or her intervention after the commission of an offence, assists the perpetrator or accomplice in evading detection of and prosecution for the offence. Mere failure to report the commission of an offence or mere approval of an offence is not in itself sufficient to render a person liable as accessory after the fact. There's no explanation given as to how Mr. Dana could possibly be an accessory after the fact in this matter. And this was raised in the main application. In the main application, Mr. Dana raised a series of questions about the prosecution. How can you say this? How can you say this? How can that be the case? How could this constitute an offence? What is the offence? Mr. Zuma's responses are well captured in the judgment of the High Court, of the full court. Can I ask the court to go to page 371, which is volume 2. Paragraph 68. What the full court held, what is most noteworthy is the manner in which the respondent has dealt with the facts pleaded in the founding affidavits of Maughan and Dana. They are blanket, bald denials of material allegations without laying any factual basis, therefore, or any explanation to justify his denials. In answer to the allegations in the founding affidavits, the respondent says the following. Now, these all come from answers to what Mr. Dana said about what is this case about, what are the facts, what's the law. A, I carry no obligation to reveal the minute details of my evidence in the forthcoming criminal proceedings. B, all these issues will be fully ventilated during your evidence and cross-examination at the criminal trial. No useful purpose can be served in dealing with them in this application. C, I leave these factual issues for their proper ventilation in the criminal trial. D, the defence is raised herein on the merits belong to the criminal proceedings. That's on the merits of the charges. E, these are matters which ought properly to be raised during or at the end of the criminal trial. So Mr. Zuma refused to try to put any flesh or muscle or anything on his skeletal charge sheet to say what actually is alleged to have happened and what's the crime, what's the actus reus. He just refused to do that. And the private prosecution, we say, is an abuse because it is simply without any foundation. The consequence of a case without foundation was explained in the full judgment of the full court. If I can take the court there, it's page 379, paragraph 97. Page 97 at the foot of page 379, this is what the court says. The next ground advanced by Dana relates to his assertions that the private prosecution is without merit and unsustainable. Our courts have held that proceedings are per se an abusive process, where they are obviously unsustainable as a certainty and not merely on a balance of probability, and that is the position here. And the court cited in support of that proposition the judgment of Holmes J.A. in 1963 in this court, and the judgment of this court in its new life in the Mapanga case in 2021. It's referred to in the record at page 380. So the private prosecution is an abuse because it is entirely without merit or unsustainable. The third reason why the private prosecution is an abuse is because it is for two ulterior purposes. Firstly, to further obstruct and delay the prosecution. Secondly, to have Mr. Dana removed as prosecutor. We say these are plainly the driving forces of the prosecution, to postpone, to delay, and to get rid of Dana. The fact that they are the driving focus is underlined by the self-evidently meritless nature of all the prosecution. Mr. Zuma can't seriously be expecting to get Mr. Dana convicted and prosecuted and convicted because there's no case against him. The prosecution is instituted for other reasons. There's no prospect of a conviction. Everyone knows that. And so a conviction cannot be the true purpose. But even if it was part of his hope, if he has been very optimistically advised that he's got a case, the fact is that there are two ulterior purposes which can't be denied, namely delay and getting rid of Mr. Dana. And the decision is poisoned by those two ulterior purposes. And we all know all those cases about mixed reasons going back to Pitt. I think it's Patel versus Potchefstroom or Patel versus Clarksdorp. But there are many cases dealing with mixed reasons. If some of the reasons are bad, then the decision falls. And so we've dealt with this in our heads of argument. If I can just give the court the references. It's paragraphs 20 to 22 and paragraphs 89 to 98. The case is without any merit at all. It is a trumped-up charge.
Can I take you back a little bit? I could have raised it earlier, but I want to appreciate what you're saying. Are you saying the release of the medical report without Mr. Zuma's consent or without his knowledge was correct? And for that matter, doesn't matter whether after the fact it was discovered that it had no confidential information, as you just said. Does it matter?
Yes, it wasn't released without. It was released after Mr. Zuma had himself made clear that he was going to file it at court. That's a waiver. When somebody says, I'm going to file this at court, it's not a confidential document any longer. So it's not without his consent. It was with he was going to file it at court. That's what the High Court found. So then, if I can then come to the question of the statutory requirements, the three statutory requirements, we deal with them in paragraphs 45 to 67. As far as exceptional circumstances are concerned, I've already addressed why this case presents exceptional circumstances. I'm not going to repeat that. All I can say is this. Thank goodness these are exceptional circumstances. But if this sort of conduct is allowed to continue, that will not be exceptional anymore. There will be private prosecutions brought ad lib by people facing serious charges who've got a lot of money or access to a lot of money in order to stop the prosecutions. They will prosecute their prosecutors, they will drag it out forever, and that will become the next tool in the attempt to corrupt and obstruct the administration of justice. It will be soon not exceptional. Fortunately, at the moment it is. Then the question of irreparable harm. We deal with this in paragraphs 56 to 61. In paragraph 57, we set out the multiple harms that Mr. Dana will suffer personally and in his capacity as representative of the state if the abusive private prosecution is allowed to continue while Mr. Zuma pursues his attempted appeals. In paragraph 57, we point out, for example, that there will be harm to Mr. Dana, who is required to appear as an accused in the criminal court on the 4th of August, which is now passed, and at the next hearing, and at the next hearing, and at the next hearing, and at the trial, despite the fact that a full court has set aside the private prosecution as an abuse. It will lead to further delay in the start of Mr. Zuma's trial. It has compromised public confidence in the administration of justice. It's a public joke what is going on. It's actually a public joke. People laugh when they say, what do we say, what are you doing? You're saying, it's okay, we're dealing with one of Mr. Zuma's cases. People burst out laughing. It's compromised public confidence in the administration of justice. There's prejudice to the administration of justice as trial preparations and arrangements have been repeatedly disrupted and wasted. Prejudice through the affliction of time, which affects witnesses adversely. Damage to confidence in the courts and the administration of justice, resulting from Mr. Dana appearing as the accused in the abuse of private prosecution, and the continuation of this as long as the private prosecution remains extinct. All of this will happen if Mr. Zuma is allowed to continue his private prosecution while the appeal is pending, or his attempted appeal is pending. Mr. Dana doesn't...
The 20-year period you alluded to,
yes.
you recall earlier on, Mr. Mpofu said that it is actually an exaggeration because not all those cases were brought by the government.
Yes.
That some of them were not brought by the government, but you were
Yeah.
as a respondent.
Yes.
Is that?
Yes.
Now, what is your comment in that regard? Because I'm trying to understand the question of delay
Yes.
within the context of those cases
Yes.
that you alluded to.
Yes. The process started, as I say, in 2003 with an application to court for the encrypted facts, which came to nothing. The 20-year period does include the so-called spy tapes case, which did consume a significant number of years. Absolutely true, and it wasn't started by Mr. Zuma. Absolutely true. When he saw that happen, he jumped on the bandwagon and he joined it. That's what he did. He was entitled to do so because it affected him. That's the attempt to undo. There were 3, 4, 5, 6, I don't know how many cases were, but they were all about the decision by the NDPP to stop the prosecution, to withdraw the prosecution of Mr. Zuma. And Mr. Zuma, unsurprisingly, jumped on the bandwagon of opposing that litigation because he didn't want to be prosecuted. One can understand that. It's not surprising, but he was party to the case. He joined the bandwagon. He participated actively. You can't just write out those years and say, well, they don't count. They were part of the sequence. But I agree.
In that case, Mr. Bartlett, he was cited as a second respondent.
Yes.
He didn't jump on the bandwagon. He was cited as a second respondent.
Yes. Well, perhaps I'm using an inappropriate phrase. He didn't jump on the bandwagon. He was cited. He could have decided to abide the decision of the court. the litigation between the DA and the NDPP, or he could have said, no, I also want to play part in this, I want to oppose also, and that he chose the latter. That's what happened. Maybe jumping on the bandwagon is an inappropriate phrase because he was put on the bandwagon by the applicant, but he didn't have to stay on it. He could have abided, but he chose to participate for reasons one can understand. But the fact is that he was an active participant in the attempt to prevent the reinstitution of proceedings against him, which lasted for several years. That's all I say. Then,
Under the circumstances, is it factually correct to say, because I think that's what Mr. Downer agrees, that the 20-year period is largely attributable to him? Would that be factually correct?
no, it would be factually incorrect. It is largely attributable to him because he's been the main institutor of litigation in this period. But there's that one big case which had all sorts of subsidiary cases, which wasn't started by him. But for the most part, most of the cases were brought by Mr. Zuma, and they account for a large chunk of that 20 years, starting in 2003. But it doesn't really, with respect, it's a pity that the terms Stalingrad and the number 20 have become an issue because that's not the question. The question is, does he have a deliberate strategy of delay? Does he have a deliberate strategy of obstruction? Does he have a deliberate strategy of trying to prevent the prosecution? The only answer to those questions is yes, yes, and yes. Is it true that each time he starts interlocutory proceedings, he takes it all the way to the end in the courts? When it fails, then he brings the next one. He brings them in series, one after the other, in succession. He waits for one to finish, and then he starts the next one. When that one is finished and loses, he starts the next one. When that one's finished and loses, he starts the next one. That's what the private prosecution is about when he ran out of road. So what we submit is indisputable, is that he has consistently, for a period of 20 years, if you want to put a number to it, done everything he could to avoid, delay, obstruct the prosecution. That's a fact. The fact that an opportunity was given him by the DA and he grabbed it with both hands, well, so be it. But he took it with both hands. Then the irreparable harm to Mr. Zuma is very peculiar. It's in our heads of argument is paragraph 62 to 67. And I listened to my learned friend this morning very carefully to hear what he was going to say is the harm to Mr. Zuma. And Mr. Zuma doesn't put up any harm, and nothing has been advanced today. The only harm, he says, is that I will be prosecuted by Dana. The harm to me, if the order of the High Court is implemented, is I will be prosecuted by Dana. But that's an illegitimate goal. That's the evidence of the abuse. You can't say the only prejudice he can point to is that he will fail to achieve the ulterior and unlawful purpose for which he started the private prosecution, namely to get rid of Mr. Downer. That's not prejudice which a court will have regard to. It's the failure of his unlawful strategy. That then brings me to the matter which my learned friend got so excited about, which is prospects of success. Our learned friend is wrong on the facts, and he's wrong on the law. Firstly, on the facts. He's wrong on the facts when he says Mr. Downer did not plead the issue of prospects of success. He did so. Can I take you to page 23 of the... And this is referred to in our heads of arguments, so I'm surprised a learned friend would make that submission, but it's page 23 of the record, volume 1. Volume 1, page 23. Paragraph 53. This is what Mr. Downer says. I submit what he has just done. He has just, in the previous paragraphs, he summarized what the High Court found. He then says, I submit that, given these findings of the High Court and the findings I summarized in paragraph 16 above, Mr. Zuma's application for leave to appeal has no prospects of success. This will, however, not deter him from bringing it, as this conduct has been an element of his abuse of court over the years. And Mr. Zuma read that, because you can then go to his answering affidavit, which is in the same volume, at page 99. Page 99, paragraph 91. When Mr. Zuma answers that statement by Mr. Dana that Mr. Zuma has no prospects of success, Mr. Zuma says the following, paragraph 91, the full court may well form the mistaken view that I do not have reasonable prospects of success in my appeal, but that alone does not meet the test of exceptional circumstances under Section 18 of the Act. Some of them are non sequitur with respect, but Mr. Zuma knows that and knew that this had been pleaded. And what it was pleaded is Mr. Dana said, the reasons why I say he has no prospects of success are set out in the findings of the High Court, which I've identified. So he's pleaded it and he's alleged it. Our learned friends seem to suggest that in this application, a Section 18.3 application, he must repeat the entire case which has been argued already before the High Court and in which a finding has been made. That's not so. You can't be required to plead the whole thing all over again, make all the allegations, just repeat everything that has been said. You plead why the circumstances are, why the requirements are met, you plead all the harm and so on, and you set out the facts. And on the facts, Mr. Dana said there is no reasonable prospect of success. Of course, this illustrates the difficulty that this court has struggled with in these appeals, because it was in any event no need to tell the full court what was in the record and what had been found, because the full court knew. It had heard the case. It knew. It had written a 60 or 70-page judgment dealing with the facts. There's no point in repeating all of that. The problem this court faces, as is pointed out on a number of occasions, is that this court doesn't have that record. The High Court had it. This court doesn't have it. And that is, with respect, one of the matters that gives rise to the debate about prospects of success, whether they're relevant. And so, I say again that the whole argument of our learned friend on prospects of success falls to the ground because Mr. Dana did plead it. He did allege no prospects of success, and he said why he alleged it. Then, as to the law, we've dealt with my learned friend relies on the Gauteng full court decision in Bila. Can I take the court to what was said by this court in the name's gone right out of my head. In the Knoop case, at a certain stage one starts forgetting names. In the Knoop case, it's in paragraph 70.2 of our heads of argument. And we say the following. The court in Bila, the Bila decision was made in 2019. We say in paragraph 70.2, the court a quo was bound by the 2020 decision of this court in Knoop. This court held that the effect of section 18 sub 3 is that, now I quote, an applicant for an execution order must prove three things, not four things, three things, namely, exceptional circumstances, that they will suffer irreparable harm if the order is not made, and that the party against whom the order is sought will not suffer irreparable harm if the order is not made. The court then considered the question of prospect of success, and the court said the following, it's at the top of page 25 on our heads of argument. It left open the question, quote, whether there is a discretion once that's those three requirements, are present, and if so, whether the prospects of success should affect its exercise. So this court, in its most recent judgment on the matter, far from saying prospects of success are a requirement, it says, no, there are only three requirements. Far from saying you have to plead, it says nothing of the sort. Far from saying this is an essential element of the case, says we're not even sure this is relevant. That's a matter to be decided in due course, whether the discretion arises. And so the reliance on Bila is perplexing, because it is inconsistent with what this court found a year later, saying there are 3 requirements. And as to prospects of success, well, we leave open the question whether they are relevant at all. They're certainly not a requirement. The question is whether they're relevant at all.
Are you then contending that in this case, its facts are not appropriate for this court to clear up that
Justice Machumi, one day this court is going to have to, somebody in this court is going to have to try to clear up this thing, because the decisions are, the decisions say we're not sure, but there's inconsistency in the decisions. This is a case in which the court could say we're now going to decide whether prospects of success are a relevant consideration in the exercise of the discretion. But I submit that there's no need to go there.
Depends on whether or not we get it.
Yes, there's no need to go there at all. And I would submit that actually it would be more appropriate to do so in a case where this is the specific focus, this issue is the specific focus of the case, and the court can really be properly briefed, and the focus can be dealt with, can deal with that instead of all the things that we have to deal with, or that you have to deal with in this case. So it doesn't feel to me like an appropriate case for this issue to be dealt with. But for the reasons I already submitted, Mr. Zuma has no prospect of success in any event. Even if prospects of success are relevant, Mr. Zuma has no prospects of success in the proposed appeal. He's got 1 down, 2 to go. And conversely, Mr. Dana has overwhelming prospects of success in the proposed appeal. The final thing is I need to say something about, but not addressed by Leonard Friend, and I say so, I address it with hesitancy, but I do feel obliged to address it, is the question of one of the ground of appeal, I think it's ground of appeal 7, which is bias on the part of the court. It's a very serious allegation to make against the court. The court is biased. This court has heard nothing in support of that assertion. There's no evidence to support that assertion. When you analyze the reasons why it's made firstly because the court found against Mr. Zuma. Well, that's not a basis for finding bias. And secondly, because of, let me get the phrase right. It's a perplexing phrase. It's still in our heads of argument from paragraph 99. It's the attitude, it's the findings which were made, the inexplicable findings, well, then the remedies appeal. And then it's the attitude of the judges towards counsel and or his client. Now, it's not clear which of the 3 judges, was it all 3 of them? Was it towards, what was their attitude towards counsel? Was it the attitude towards counsel or the attitude to his client? And what are the facts on which this very serious assertion of bias is made? And the judgments of this court and the Constitutional Court and the High Courts are replete with serious judgments saying these sorts of allegations should not be lightly made. They should be made only when there's proper evidence to support them, and they should be made with caution. It's unfortunately become a habit in our country when you don't like the judgment given by a court to say, oh, the court was biased against me. It has to be deprecated. In fact, it has to be stopped. So, finally, we submitted that Mr. Zuma's stratagem is making a mockery of our system of the administration of justice. He is, in truth, a vexatious litigant. But for present purposes, it's not necessary to go that far. It's enough simply to dismiss the appeal with costs on a punitive scale. Unless there are any questions from the court, those are our submissions. On a punitive scale, because of the manner in which this litigation has been conducted, and particularly the allegations about the judges being biased. That's made solemnly in a notice of appeal, not justified anywhere. That's a matter for punitive costs. It's the least we submit that a court will do to protect its own process and to protect the process of other courts. Courts need to look after each other.
legislature creates an automatic right of appeal. It creates a right for the appeal to be heard on an urgent basis. I think all of that is incontestable. But what still remains is the question as to whether or not that right in any given set of circumstances should be exercised.
Yes, ma'am.
And I think that is what I've been grappling with
Yes.
from the time I started to read
Yes.
this record.
Yes.
And perhaps not very elegantly, but I've tried to raise that with Mr. Important, for example, and I'd like you to deal with that if at all possible.
Yes. I just want to find the judgment of the main judgment of the High Court. In the main case, the main application, the court ordered costs on the attorney and client scale, including the costs of two counsel. I think I'm correct in saying that in the, let me find it, in this case, the court ordered Mr. Zuma to pay the costs occasioned by unsuccessful opposition, including the costs of two counsel on the scale as between attorney and client. There's been no appeal against those orders. Well, I don't know, but this is not an appeal against that judgment anyway. I do submit that this application is, to put it at its lowest, unjustified. It entirely lacks merit. The opposition, not the application, the opposition is unjustified and entirely lacks merit, and is demonstrated, if by nothing else, by the fact that Mr. Zuma came fighting fit to court. He filed his furious answering affidavit, trying to prove something which wasn't even an issue, namely that Mr. Dana is a bad person and shouldn't be allowed to prosecute him, which was entirely misdirected. It was inappropriate. It was impermissible. It was all of those words. And for all of those reasons, too, we submit that it would be appropriate to order costs on the attorney and client scale. It's really, Justice Ponner is with respect correct. It's one thing to say I've got a right to institute proceedings. It's another thing to say I can do so willy-nilly even when there's no merit to them. If that were the case, then we would really be in trouble.
See, what prompted the question is, if you go to page 85 of the papers, the first few lines, and that's the answering affidavit to the application.
Yes.
What's suggested is, even if the relief sought here is granted, public prosecution will still not take place with Mr. Dana as a prosecutor.
Yes.
The only gain which he will make is to escape the clutches of the law.
Yeah.
That's very telling, isn't it?
It is telling, Justice Ponner. It is telling. It tells one what's really going on here. Yeah. It's really misdirected and inappropriate, the opposition, and the tone of the opposition. These pages after page after page after page of abuse and insult. Really, this sort of thing has to stop.
In part, those kinds of allegations that one sees in the answering affidavit that provoke some anxiety in me as to whether or not we were truly dealing with a decision in this case that will have some practical effect on us.
Yes. Well, the court, I submit that the court is fully entitled, if the court finds that that the appeal is properly before it as a result of the section, the court is, with respect, fully entitled to say there's no consequence will follow from it and to dismiss the appeal on that basis. The court is entitled to do that. Thank you, Madam President. Yeah, I'm sorry.
I am following up on what my brother has raised. I want to appreciate that if we say there are conflicting judgments, or not necessarily conflicting, but there's different messages around the prospects of
Yes. No, the prospects of success. What my submission is this: that the court would be entitled to say, and might choose to say, there is a continuing debate about whether prospects of success are relevant to the exercise of our discretion. That's a matter to be decided on another day. To the extent that prospects of success are relevant, they weigh in favour of dismissing the appeal, because Mr. Zuma's prospects of success in the appeal are so poor, and Mr. Downer's prospects of success are so strong. And so the court would say, we don't need to decide that now, but because in any event, whatever the law is, the prospects of success are Mr. Zuma's prospects of success are so poor.
Can I not say that the last word on the prospects of success is the judgment of AfriForum?
Yes, I think that's right, actually.
Justice Wallace,
I think that's right. Yes,
I not say that judgment is wrong, but there is one specific paragraph in the judgment where it is quite clear that their court's view on that aspect was that prospects of success are a relevant consideration, because in paragraph 50,
yes.
this is what Justice Zuma said. I mean, I'm hearing the approach of Winsworth. In fact, Justice Alliance serves as a prime example why the prospects of success in the appeal are relevant in deciding whether or not to grant the exception.
Yes.
Justice Wallace then refers to the TTT.
Yes.
He does not criticize. So it would seem to me that the last way on the issue of prospects of success is that paragraph 15.
Yes, it is with respect to the last positive statement made on that question. I respectfully agree. But what Justice Wallace said and what the court agreed with is that that question really remains open. It said, what Justice Wallace said is, if I can find, here it is, I've got it here. He said he left open the question whether there is a discretion once they are present, and if so, whether the prospects of success should affect its exercise. So it left that question. Justice Wallace pointed to the difficulties, including the difficulty which would face this court, in deciding prospects of success without the record, which is usually the case. Not always, but usually. And so the last definitive statement is the statement by Justice Fourie in AfriForum. That is, with respect, correct.
In so many ways, he says it's a prime example why prospects of success in the appeal are relevant.
Yes.
So we have 5 judges of this court.
Yes, that is. The question, Madam President, is what one makes of it when this court subsequently says we leave open the question whether the prospects of success are relevant. That casts some doubt in it. I don't want to make a mountain out of this molehill. It's a perplexing situation because the law is perplexing in this regard. One can understand the justices struggling with it and trying to make sense of it. If prospects of success is a requirement, then this court is in serious trouble because it's going to have all the records are going to have to be before it can decide that matter.
Can I just raise this? Who's determining prospects of success? Is it the court below at the time it's determined this application, in other words, the execution application for shorthand, or is it us when we're sitting on appeal?
Well, it's
it's the court below that's determining prospects of success. If it's doing so in the exercise of its discretion, is this in the nature of a broad or narrow discretion, or simply at large to interfere? Yes, I mean, maybe throw away lines and judgments, but truth be told, none of them
Yes.
If it's an exercise by us, can we now take into consideration that the court below took the view that there are prospects of success? It dismissed an application for leave, and to some extent that answers that debate. So you know, I mean, I know I sounded a bit like a juggler with a dozen balls in the air, but you can see part of the dilemma that confronts us.
Yes, and the dilemma is not made easier by the fact that the court or quo, when it heard this application, knew that an application for leave to appeal was pending. And the court said, I'm not going to deal with prospects of success, but I don't want to prejudge that issue because there's an application coming before me dealing with that. And so the court below was effectively disabled from deciding prospects of success because there was an application for leave to appeal pending. Then the application for leave to appeal is heard, and the court in very firm terms dismisses it and says there are no prospects here. That surely is a matter which this court can have regard to in exercising whatever discretion it has.
Yeah, I mean, that's what I was struggling with. That can't be a totally relevant consideration.
Yes.
The fact that the application for leave hasn't been dismissed.
Yes.
Certainly not if we are to exercise that power sitting in the
Yes.
court of appeal.
Yes. With respect, that is so.
But it also takes us back to the issue of costs. And then the period, why punitive, if it is such a very interesting, you know, from
Yes.
different angles.
Yes.
So
Just-
Mr. Zuma came here, why punitive? Because
Yeah.
lawyers are still grappling with the issue. Whether it's
Yeah.
wrong.
Justice Muchumi, I don't want to make an issue of it. It's another of these things which is an interesting question which will have no consequences because I don't want to be rude, but the costs aren't going to be paid anyway. Thank you.
Can we just get an indication of how long more or less you will take? You had indicated that you would take 45 minutes.
Yes, that is still the plan. The only difference is that I don't need protection time.
Yes, but I was thinking that maybe you are going to suggest that you are going to take less. I think if you are going to take 45, you might need to take a luncheon and then that will make it a short one.
As the court pleases.
The agenda will be in 30 minutes, so it's 10 past.
Thank you, Justice Miller.
It's fine.
Thank you, President. What I propose to do is to address 5 topics. The first one is what has been described by Mr. Mpofu as a point in limine that has to do with prospects of success. The second is exceptional circumstances. The third is the presence of irreparable harm on the part of Ms. Maughan. The fourth is the absence of irreparable harm on the part of Mr. Zuma. And the last will be to deal with what I have described as a cynical abuse of the legal system by Mr. Zuma. Let me deal with the first one, which is the issue of the prospects of success. It is easy to dispose of because the argument, as I understand, is twofold. The first is that we mentioned it, but did not sufficiently deal with it in the papers. That's the first criticism. And the second criticism is that the Judge Akuo also did not deal with it. And the underlying legal premise is that it is a requirement. Mr. Mpofu calls it a fourth requirement. So let me first deal with the evidence, what transpired. The prospects of success are dealt with in the founding affidavit of Ms. Maughan at page 341. So if you go to page 341 at paragraph 11, she states there, despite the lack of prospects of success on appeal, it says lack of any prospects of success on appeal. Shortly after the judgment was handed down, the J.G. Zuma Foundation issued a public statement indicating that Mr. Zuma intends to appeal it. The statement issued on Twitter at 11:25 on 7 June 2023 is attached. It was issued within 3 hours of the judgment being made available. Then it is also mentioned, so it's clear there, the assertion is made that there are no prospects. In fact, it says lack of any prospects of success. And at that point, we don't yet have the application for leave to appeal. Then it is also dealt with at page 346 at paragraph 24.5. And you will see there, it states the prospects of success on appeal by Mr. Zuma are so poor that his application and likely series of applications for leave to appeal can serve only as a dilatory tactic in his own criminal trial and to negate the protection that I'm afforded by this court's order against further unlawful harassment and intimidation. So in 2 parts, it is positively asserted that there are no prospects of success, and then in the second part, they are so poor that any pursuit of that leave to appeal would be dilatory. Then the leave to appeal is brought. And this is then dealt with in the reply. So you will see at page 493, which is the first time it is dealt with in the reply. At 493, at paragraph 11. And it's a full exposition there of the arguments to be advanced. And it states here at paragraph 11, at page 493, fourth, Mr. Zuma contends that his application for leave to appeal has good prospects of success. It appears that Mr. Zuma places primary reliance on the argument that the full court's order violated the principle of subsidiarity because it granted an order that he contends is not permitted by Section 14.2 of the Superior Courts Act, and hence that a constitutional challenge to Section 14.2 was required. This argument has no merit whatsoever. It is, with respect, patently bad. Without purporting to be exhaustive, the principle of subsidiarity finds no application in these circumstances. Mr. Zuma ignores all the precedents dealing with the court's duty to prevent an abuse of its process. Mr. Zuma proceeds from the erroneous premise that an unlawful and valid criminal prosecution was instituted against Ms. Maughan, and Mr. Zuma has misconstrued the authorities on which he relies. The issue will be addressed in argument to the extent necessary. And then it goes further at page 494 at paragraph 13. And there the attorney on behalf of Ms. Maughan addresses the issue of the honors squarely. And then he says, Mr. Zuma claims that Ms. Maughan has failed to discharge the honors on the applicant to establish reasonable prospects of success on appeal. I deny that there is any such formal honors. However, even if there is, the prospects of success are readily apparent from the reasoning of the judgment and the grounds on which the full court found Mr. Zuma's institution of a private prosecution against me to be unlawful. The prospects of success are, in any event, a matter for legal argument. So again, it is in paragraph 11, there is a full argument. In paragraph 13, it is stated that the prospects of success are apparent from the reasoning in the judgment itself. So they are so poor that you simply have to put the judgment on one side and put the leave to appeal on one side to realize that they ought to be dismissed without more. But they go further. The discussions about this issue goes further. You will see at page 496, paragraph 18, where the legal argument continues to justify why the judgment was correct. It says, eighth, Mr. Zuma repeatedly attempts to present his private prosecution of Ms. Maughan as akin to any public prosecution. It is manifestly not so. The Constitution confers the power on the NPA to institute criminal prosecutions and requires that this be done without fear, favor, or prejudice. Mr. Zuma fails to recognize that his prosecution of Ms. Maughan is an unlawful prosecution pursued in a private capacity for an improper and ulterior purpose, and which constitutes an abuse of the court process. Then so that would be at paragraph 18, and then the last is at page 499 at paragraph 26. It's a long paragraph. In fact, it's both paragraph 26 and 27, which goes to the issue of how this private prosecution violates Section 16 of the Constitution. And in any event, it's unlawful because there was not a prosecution that was applicable to Ms. Maughan. So, contrary to the assertions made that prospects of success are not dealt with, they are in fact comprehensively dealt with in at least 1, 2, 3, 4, 5, 6, 7 paragraphs. They are also dealt with in the judgment at page 593, which is the last volume, I think it's volume 4. At page 593, at between paragraph 583, between paragraph 33 and 37. And in paragraph 36, which is at 584, what is stated there is not that the court will not address prospects of success. It simply says, look, we will in due course deal with the prospects of success when we receive the application for leave to appeal and address it. And then they say, but insofar as the leave to appeal is based on the issue of subsidiarity, a mere perusal of the judgment will show that it was dealt with in some detail. If indeed the main thrust of the first respondent's application for leave to appeal is the failure of the court to deal with the subsidiarity aspects, then prospects of success are indeed slim. So it's paragraph 36 of the judgment at page 584. So far from eliding prospects of success, they say, look, we are still going to deal with prospects of success fuller, but insofar as they are based on this aspect, we find that they are slim. So it's in the founding affidavit, it's in the replying affidavit, it is in the judgment. But prospects of success in relation to what precisely? Because there are two prospects of success in the issue. One is what Mr. Badlander addressed, which is the prospects of Mr. Zuma successfully prosecuting his intended accused. The other is the prospects of success of Mr. Zuma overturning the findings of the High Court that his decision to privately prosecute Ms. Maughan and Mr. Downer was an abuse and should be set aside on that basis. So it's the second category of prospects of success that are relevant, which is he going to succeed or is he likely to succeed on appeal? Mr. Badlander has made the point that the prosecution itself is based on a contrivance. And it's clear that as far as Ms. Maughan is concerned, it's actually a contrived prosecution. And we see this just by observing the number of times Ms. Maughan has been mentioned even today. She's actually a peripheral player, but she remains an accused person. But we also see that the prosecution against her is contrived for another statutory reason. Ms. Maughan is not mentioned in the Section 7 nolle prosequi. That was the finding of the High Court. There is no debate that she was mentioned. She's not in the certificate. You have no right to prosecute anyone privately under Section 7 of the Criminal Procedure Act unless they are in the nolle prosequi certificate. She is also not in the number of parties that were alleged to be suspects when the affidavit was submitted in favor of or in motivation of the nolle prosequi certificate. She's not mentioned there either. So she's not mentioned when the process is instigated. She's not mentioned when the certificate is issued. She's not mentioned even in the second certificate at all. So there is no basis at all to prosecute her because there is no viable case in the absence of her name being identified in the nolle prosequi. And we see this as a jurisdictional requirement that is expressly mentioned in Section 7 of the Criminal Procedure Act. That was the finding of the High Court. But in addition to this being a finding of the High Court, the High Court also expressly, comprehensively explains why the prosecution of Ms. Maughan is an abuse by Mr. Zuma. And you will see this in the judgment of the High Court. It's in volume, I think the judgment is in volume 2. Yes. And the paragraphs that are relevant, you will see from page 387. That's where the judge pertinently addresses itself to Ms. Maughan. So at page 387, the first finding of relevance is at page 388, paragraph 120 and 121. So in 120, the judgment finds, prior to the institution of the private prosecution, she has reported on matters involving the public protector and politically charged matters, which has drawn criticism from the Jacob Zuma Foundation, supporters of the respondent and members of the respondent's family. As a journalist, she is seen as part of a hostile media with menacing commentary. She is regarded as an implicated party in matters of downer and co-accused who has provided a statement to the police. And then in paragraph 121, it is evident that the respondent, that is Mr. Zuma, harbors great hostility towards her and is demonstrated in his affidavit by the respondent's associates and supporters. And then they deal with all of the tweets. But if I can take the court to paragraph 125 at page 389, where it is stated that the court says, having regard to the respondent's answering affidavit, his personal animosity towards Maughan is exposed. She is alleged to have colluded, conspired, and been in partnership with the state prosecutors perpetuating a false narrative about his conduct towards litigation and the delays in the criminal trial. This is repeated on a number of occasions in the answering affidavit, and his hatred, impatience, and vitriolism towards her is patently obvious. And then paragraph 28 and 29 of Mr. Zuma's answering affidavit are extracted. And paragraph 126 is also relevant. And then paragraph 130, which is at 391, states the following. Maughan also indicates in her affidavit that the respondent will stop at nothing to malign her and falsely implicate her. As a further example of this, she alludes to the respondent's reference that she deleted tweets on 9 August 2021 relating to medical information. In support of this allegation, he annexes Annexure JZD7. In support of this, that's a grammatical mistake. However, such annexure does not purport to support this contention, but further evidences an attempt to manufacture evidence against him. Now, this is an extremely serious finding against a purported private prosecutor. A finding that an ordinary prosecutor under the NPA has manufactured evidence would be extremely serious. If that prosecutor had been an advocate, they would have been struck. But this is a private prosecutor who purports to act in the public interest in pursuit of a claim that he says justifies private prosecution. But it is found by the judges that in the course of doing so, he has manufactured evidence against the intended accused. So we have here three extremely serious findings that are underpinning the allegation of abuse. One is that this is an attempt to stop the continuous reportage by Ms. Maughan. The second is that the vilification goes beyond Mr. Zuma and has been taken up furiously by his supporters. And thirdly, there has been evidence manufactured to falsely implicate Ms. Maughan. Those findings of the High Court, strong as they are, simply demonstrate the utter lack of prospects of any success on appeal. This is why the court says, if we assume that the only basis on which you will be appealing is this subsidiarity, then you have no case. But these are the findings, and that is why in the replying affidavit it's expressly stated that it is apparent from the judgment that this appeal has no prospects of success. So, to round up then this first topic, if you are to decide this on the facts and not on the legal debate, interesting that as it may, you will find that Ms. Maughan expressly dealt with prospects of success in the founding, expressly dealt with prospects of success in the reply. The judgment expressly dealt with prospects of success, and if yourselves have regard to the judgment itself and the findings that it makes on uncontested facts, because these facts that I've cited are uncontested facts, two of whom arise directly from the affidavit of Mr. Zuma as demonstrating the hostility and the animus, and then the manufacturing of the evidence. So it would be clear that this case has got zero prospects of success. So the charge is contrived, the allegations are manufactured. We then go to the second issue of exceptionality. We must make one point clear at the outset of our address. The first is that you are a court of appeal. You are not the court having to decide whether exceptional circumstances exist or not. That has to be decided below. You only have to decide whether the outcome of the court below is correct or not. And when you do that exercise, you are not going to look at the reasons given for the judgment, because there is no appeal against the reasons. You will look at the outcome of the judgment. So, on the three areas, and the judgment I've referred to clearly deals with all three areas. Exceptional circumstances, you will find this from page 581 at volume 4 of the record, where the judge addresses himself to exceptional circumstances. It's 581, not 581. 578, that's where it starts. From paragraph 7 to 581. Yes, that's where it starts. So the learned judges address themselves to exceptional circumstances, and they deal with all of the authorities, from Justice String to the most recent Knoop judgment, and all the way. And they then explain from paragraph 26 why the arguments of Mr. Zuma were flawed. And they explain the reasons why those arguments were flawed. And so those are the passages in which they deal with exceptional circumstances. The question is whether or not the conclusion that there were exceptional circumstances in this case can be impugned. Number one, it cannot be impugned that a prosecution of a journalist designed to prevent that journalist from reporting and with the corresponding disadvantage it places on the public from receiving information itself implicates Section 16 of the Constitution. Number two, it cannot be denied that a private prosecution in itself, and this is a point made by Mr. Badlander, is an exceptional circumstance. The default position is that the NPA does prosecutions on our behalf, and the exception is for private prosecutors.
Sorry, Mr. Detective, may I take you back a little bit? You submitted that in considering exceptionality, we should not look at the reasons for the judgment, but rather at the outcome.
Yes.
When I read the Blue judgment, I saw that there was a lot of criticism directed at the reasons of the court of law. In fact, at some stage the court said that that court had shirked its responsibility. So my question is, what would then be the point of alluding to that if it is completely irrelevant? If
No.
we should not consider it at all and consider only the outcome?
No, the law is simple on this topic, Justice Moleman. You cannot overturn a judgment because you disagree with the reasons. You can only overturn a judgment because the outcome is wrong. So you can write in the judgment that it's a salutary principle that judges must reason their judgments out. But you cannot say, I find that the judgment was wrong and therefore I'm overturning it because of the paucity of reasons. That is not the law. It is required that judges must provide reasons for their judgments. But the correctness of the judgment is what is before you. We're asking you to dismiss the appeal because whatever deficiencies can be identified in the reasons, that's not a basis to overturn a judgment.
So your response is that those were just comments that were made to emphasize the importance of giving reasons,
Precisely.
but not to say that the reasons themselves have to be considered in detail.
No, the reasons must always be considered. The question is, when will a court of appeal overturn a finding of a court below? A court of appeal will overturn a finding of a court below if it is satisfied that it was wrong, the conclusion was wrong. If, for instance, an application is brought and it is dismissed, you have to dismiss the appeal if you come to the same conclusion. But you cannot say, we think that he was right in dismissing the appeal, in dismissing the application, but because it did not give reasons for it, therefore we will grant the application. So the question is, when will you interfere? You will only interfere if you come to the view that the outcome was wrong. So you obviously must always encourage the judges to provide reasons, and the reasons must make sense, but you cannot use that as a basis to overturn a judgment. That's not the law. In fact, what I'm saying is an express finding of this court by Justice Rogers. In the...
I think the point you're making is the following, which is a fairly trite proposition.
Yes, indeed.
And that is an appeal lies against a substantive order of the topic rather than the reason.
Yes, indeed. I don't...
I think all you're doing is you're sort of fleshing that basic proposition.
Yes, indeed. Yes, I don't need to look at authorities on this. It's truly trite. Now, so I've made the first two propositions about exceptionality. The third, which was actually pursued by my client, is the exceptionality of a former state president prosecuting a journalist. This is a truly exceptional circumstance. It does not happen often that a former state president prosecutes a journalist. The fourth is what Justice Ponan already referred to in the exchange with Mr. Badlander, which is the finding is that there has been an abuse of the power to privately prosecute that is conferred by a statute in terms of Section 7 of the Criminal Procedure Act. Now, let me spend a minute on this. Mr. Zuma is in fact engaged in a cynical manipulation of the legal system. That is truly what is going on here, because sometimes the term abuse masks what is truly happening. We are talking about a cynical manipulation of a legal system. Section 7 of the Criminal Procedure Act, on which he purports to rely, is not to be used to punish. It is not to be used to harass. It is not to be used as revenge. It is not to be used as an instrument to settle a score. It is to be used for legitimate reasons. All public power, because Section 7 is in fact statutory power, can only be used for legitimate goals that the statute contemplates should be used for. One cannot turn that on its head and seek to achieve ulterior goals. When one does so in circumstances such as this, where in the first place they turn the prosecutor, Mr. Downer, into an accused. In the second instance, they turn the journalist into an accused. They are manipulating the instruments of the law. And this has serious consequences for the constitutional order. It truly does. And when the judges do not stamp out this abuse clearly and within the first available opportunity, they inevitably encourage it because they show that the cynical manipulation of the system pays. And that is why you have to look at this case deeply and seriously, because it has implications that go beyond these two parties, because it has implications for the rule of law and for the authority of the judges under Section 165 of the Constitution. And that is why we say it is a truly exceptional case. And Mr. Butlander was not exaggerating when he said, if this is not an exceptional case, we will never get an exceptional case. It will in fact become a norm. And that is in fact one of the unique features of this case and how perverse it is that Mr. Zuma's constant cynical manipulation of the legal system has turned something that would have shocked you 2 years ago into a norm. So we would say that there can be no doubt that the outcome of the court below as to the existence of the exceptional circumstances cannot be faulted. And I have already referred to the specific findings that were made by the justices, particularly the finding of manufacturing facts.
I'm trying to wrap my head around what you're saying now.
Yes.
On sort of the uniqueness of this case.
Yes. Yes. There is a light that's blinding me. I'm terribly sorry. Yes.
And I'm not saying what you're saying is not valid. I'm trying to imagine a situation where an ordinary citizen, assuming we remove the former president's status from him, he's an ordinary citizen, comes to the court in terms of Section 84 of the Constitution and says, I understand I have a right after this and this had happened, automatically I have this right to come before this court. How can it be an abuse, if anything?
No, I am not suggesting that.
To take everything off on his status and everything as an ordinary citizen now.
No, the judgments we rely on, there are three that we rely on that found Okay, there's a problem with my machine. I just want our heads. We've relied on 5 judgments. 3 of those are ordinary citizens, and 2 are Mr. Zuma, in which it has been found that the private prosecution, starting all the way from Solomon in the 50s, that was an ordinary citizen. The mere fact that Mr. Zuma happens to be the president who is facing a criminal charge himself adds to the exceptionality, but it has very little role on the abuse. The abuse shows that this is an exceptional case. And if anyone, whether it is Mr. Solomon or I think the other, yes, found, thank you, Gcilichana or Nundala and Van der Venter, any of those, if they had abused the legal system by running a contrived prosecution and the court had stopped the prosecution and then they had tried to get it enforced because of an appeal, then we would say to the court that they should entertain it, because what the court cannot allow is a manipulation of the legal system. The issue is Mr. Zuma should also not be excused from the rule that applies to the others. That's the true submission. So it would be the same outcome, whether it was Gcilichana or Van der Venter or Nundala. It is in fact cynical for Mr. Zuma to say my status doesn't matter, but at the same time my status matters. Anyone who manipulates the legal system to achieve ulterior ends should be stopped by the judges. Then I want to move then to my third topic, which is the second element. Let me keep it here because my computer is dead. Which is the second element of Section 18, which is this issue of irreparable harm. We have referred to the judgment of S versus Western Areas, a judgment of Justice Howie when he was president of this court, which makes a simple proposition. The appearance of an accused wrongly in court, and in that case, it's the state that was charging them, which the state is entitled to under Section 179 of the Constitution. But the appearance, even for purposes of bail, is an infringement of the right to freedom of movement. So here is the point. Ms. Maughan, at the time she brought this application, was required to appear in court, I think, on the 4th of August. She is now required to appear in court again on the 1st of November. That appearance is a violation of her right to freedom of movement. This is the same finding that was made by the full court in Johannesburg when it excused President Ramaphosa from appearing on the basis that it's the mere act of forcing a person to appear before an unlawful and an abusive prosecution. That, in a sense, gives legitimacy to the abuse, because seeing Ms. Maughan in the dock in circumstances that are abusive is legitimating the abuse. And that is why when she won her case, she was then entitled under Section 18 to be excused from the appearances. There is an argument made in the heads of argument of Mr. Zuma that the prosecution will continue no matter what. Ms. Maughan may decide to come and not to come. That's a different debate. If they want to go to an empty court, they can do that. But the fact of the matter is that Ms. Maughan should not be compelled to appear in court on the pain of a criminal sanction, because if she doesn't appear there, she's committing another crime. So she is always compelled to appear in court. That harm can never be restored. It's harm that she simply can never get back. But the other problem with it is the chilling effect. It is truly chilling that a journalist in the position of Ms. Maughan, I would even submit a prosecutor in the position of Mr. Downer, it is truly chilling that they must perform their duties under the surveillance and the constant threat, quite menacing threat, of a private prosecution. Because when you actually break this thing down, Ms. Maughan gets a piece of paper which she reports about, and on the correct sequence, that piece of paper is already part and parcel of an application by Mr. Zuma. She gets a piece of paper, she reports it. It's a classic job of a journalist. And there are many judgments that say a journalist can get documents. They don't have to question their sources, whether or not the sources have got those legally or illegally or anything of the sort. What she is being charged with, let's be honest, is for reporting. That's what is being charged with, is for reporting. You have other gymnastics about Section 41.6 of the NPA does not concern itself with a journalist, it concerns itself with the disclosure of information that is from a docket, etc. The true issue around Ms. Maughan is reportage. It's the core function of a journalist. And that is why we say it is truly spine-chilling to think of the consequences of what is happening here. And that is why this must be stopped, and one should not be beating about the bush in a case of this magnitude. So,
it's slightly more narrow than that. It's actually the timing of the reporting.
yes,
Because, truth be told,
yes,
he had waited a little while.
yes,
These would have, and if the documents had indeed been filed in court, they would have been public documents,
Yes.
and then she would have been free to report.
yes, yes,
So the essence of the complaint,
yeah,
as I understand it, I accept everything that you've said.
yeah,
But all I'm suggesting is that the essence of the complaint is far narrower. It's
Yes,
actually
yeah.
the timing of the
yes, exactly. But that precisely shows why this is an egregious abuse. It's narrower than I tried to portray it. In fact, I gave it legitimacy it doesn't deserve. So we say that this is not a harm that she can get back. It's chilling, not only to her, but to everyone else who is in her position. It is also chilling because it is a violation directly of her rights to freedom of movement. That is enough.
Is the argument not that she's in that space and she should take it as it comes?
No, there are no journalists that are...
If one takes into account that Mr. Zuma feels strongly that his own rights are being transgressed, therefore, even if she goes, it's what she does. It's her job. It's a journalist. From time to time, we get all these criticisms.
Journalists are happy to be criticized, but there are no journalists in this country. There is not, in fact, a single journalist in this country right now who is facing a private prosecution. It's only Ms. Maughan. And one cannot, in fact, I would say, sanitize the egregious nature of this conduct by saying it's par for the course. It's not par for the course. It's a journalist who has been singled out for punishment, vindictive punishment, not legitimate punishment, vindictive punishment.
This can't be dressed up as even to criticism
No.
of the journalist.
But there's no criticism at all. Yeah. So what is happening is that she's turned into a criminal accused. And then all of the supporters, and the record is actually replete with this, all of the supporters celebrate her appearances in court in very cynical and vindictive ways.
That's very worrisome.
Yes, precisely. And the evidence is so clear on this. So it goes beyond Ms. Maughan. It's precisely this chilling effect. And then someone to say, well, take it, that is what happens to journalists. That is not what happens to journalists. Then you have, so those two submissions are enough.
But it shouldn't be happening.
Yes.
I'll say if it does happen, it shouldn't be happening.
Yes, indeed, it should not be happening. And it's not the norm. I mean, this is the point Justice Machumi is putting, that, well, journalists are criticized. Journalists are criticized. You write a newspaper report and you say, no, this journalist is stupid, whatever. But you don't charge criminally journalists. That's the chilling effect. And particularly the manipulation of the system of obtaining a summons under Section 7. It's the manipulation of the legal system. So then we then deal with the irreparable harm of Mr. Zuma. Let's really reflect on this. What is the harm to Mr. Zuma? What harm is he suffering? Because what he really wants to do is to continue the abuse, is to continue the manipulation of the legal system. But he now wants to do it with the imprimatur of the judges. Why should he do that? Why should the judges play along? If he wants to prosecute Ms. Maughan, he will do that once his appeal. He is very confident about the prospects of that appeal. Once it succeeds, he will prosecute her. But he has lost resoundingly right now. He should be stopped from prosecution. This thing has become a spectacle. Mr. Badlander called it a national joke. So, quite plainly, there is no harm, let alone irreparable, that Mr. Zuma suffers. So I began then, so I must now end with the abuse, but the court would have seen that the abuse is a theme of the judgment à cour. We have dealt with this at the beginning of our heads of argument. What we ask this bench to take into account is that Mr. Zuma has an established propensity of vexatious litigation. We have cited here at least 12 separate instances where he has litigated with a lot of enthusiasm, but with no results. Now, one can try and neutralize the submission and say the mere fact that you lose doesn't mean that the litigation should not have been instituted. But the frequency and the nature of the cases that are being brought clearly illustrate that this is a vexatious litigant. You debated earlier with Mr. Badlander the question as to whether Mr. Zuma should be criticized for the 20 years or not criticized for the 20 years. That is not our bone to pick. What we want to illustrate in that fight, when the litigation was instituted by the DA to reinstate the charges, two things happened that contributed substantially to the delay. One was Mr. Zuma's, and we've cited this at page 7 of our heads of argument, item D. It was Mr. Zuma's decision to challenge the locus standi of the DA, which was eventually resolved in 2012 by this court. He is not an innocent party or a bystander watching. He is actively taking technical points to postpone the day of his reckoning. The second was the spy tapes litigation, of which even there he was a key proponent, which we've referred to as item E, which is the disclosure of the transcripts of the conversations recorded in the spy tapes. That is resolved in 2014, 2 years later. So it is not as if you are dealing with someone who is watching or witnessing a titanic battle between the Democratic Alliance and the NPA. You are dealing with someone who is part and parcel of the tactical litigation that is contributing to the prolongation. So far from being an innocent bystander, he is participating. He's taking every technical point that he can take himself. Now, that does not make those technical points illegitimate, but it explains the delay, that he is part and parcel of that delay. Now, all of those are finally resolved in item F in 2018. Item F at page 7 in 2018. And paragraph 3 of that judgment, it's a judgment of this court, paragraph 3 of that judgment records that within minutes of the address by Mr. Kemp, he had considered that his opposition to the DA's review had no merit. Within minutes, it's recorded in paragraph 3 of the judgment of this court, decided in 2018, that it took him minutes to say this defense has no merit. So it's easy now to say he shouldn't be blamed because this was a litigation brought by the DA. But when you examine the facts, it becomes clear that he is part of it and he cannot excuse himself from it. And then the final point on abuse, and it's a point that has already been made by Mr. Badlander, is that we are dealing with someone who is facing criminal charges. This is unlike a case where someone has been wronged. The NPA incorrectly decides not to prosecute, and then they decide, I'd rather than seek justice on my own. This is retaliatory in its nature. And once it's retaliatory in its nature, Section 7 prosecution is retaliatory by its nature, then it forms part of this picture of abuse. We would ask, therefore, that you should protect the administration of justice by dismissing this application. You should also impose a punitive cost order. This appeal is itself an abuse. The summons was an abuse. The opposition to the application was an abuse. The Section 18 was an abuse. The opposition to the Section. This appeal did not have to be taken because one could have waited until the appeal is decided on the merits. And at that point, everyone would be more sanguine and considering where they go. They did not have to run this round of litigation. They could have waited. But no, they've been hell-bent on teaching someone a lesson. But they have also made reckless accusations of bias. Mr. Badlander has dealt with those. The only thing to add there is, I think it was Justice Ponan who wrote the judgment in the funding litigation, where again the same person, Mr. Zuma, had made unfortunate accusations against the judges in Pretoria that they were biased. And that factor was taken into account in imposing a punitive cost order before this court. We would urge simply that the court should follow its own precedent on this issue by imposing another punitive cost order on Mr. Zuma. So we would submit, therefore, that the application is wholly without merit, the appeal is wholly without merit. It should be dismissed with a punitive cost order. Thank you, Justice Molema. Yes, indeed.
In the case of the judgment of Justice Wallace, concludes in paragraph 50 by saying, if the language of Section 18.4 confers a discretion, is there a full discretion or a power combined with the duty to exercise that power on proof of the requirements for its exercise? So if we are with you that the statutory requirements have been met, and it then moves us into the second phase. What is that second phase in your view? Bearing in mind the dictum there at paragraph 50.
Yes, well, if you are to apply a discretion, there is, I suppose, the first question that you have to follow is that discretion has already been exercised by the High Court, and this is a court of appeal. You are not exercising the discretion originally. The High Court has looked at the existence of those three factors. It has looked at prospects of success, and it has decided to exercise that discretion. The question on appeal is if this is a discretionary decision, is there a basis on which a court of appeal can interfere with the exercise of a discretion, depending on whether it is a narrow or a wide discretion? And there are established authorities here. In fact, the funding case is a preeminent example on this point, that make it clear you can only interfere if discretion was not exercised lawfully with the appreciation of the correct dictates or with a misunderstanding of the facts. Then the question is, what case has been made before this court to interfere with the discretion of the court below? No case has been made. No case has been made that discretion, after those three elements existed, has not been exercised properly in accordance with the behests of justice and the correct appreciation of the law. And so, therefore, as a court of appeal, your job is a relatively simpler one if this is a discretionary question. This fourth element is a discretionary question. The court of appeal simply asks itself, this discretion has been exercised. What is the basis on appeal on which we can interfere? The basis, we know, those are the three requirements. It must be a misunderstanding of the law, a misappreciation of the facts, or some sort of a gross irregularity or gross injustice. Other than that, you leave the judge a quo as he decided. But the debate, as I've been listening, seems to be that this court is itself going to place itself in the shoes of the High Court. That, with respect, is the wrong approach on a discretionary question. But if you are to place yourself in the shoes of the High Court and exercise the discretion ex nunc, then the question that you have to answer is, what factors do we take into account? One of it could be the existence or otherwise of prospects of success. And on these facts that we have illustrated, firstly, you have the disadvantage, you don't have the record. But on the facts that you know and the quality of the reasoning of the judgment, you will come to the same conclusion that the High Court did, that these are very limited prospects of success. And for that reason, once those three statutorily ordained elements exist, you have to enforce the judgment. But the primary point I urge the court to remember is that it is dealing with a discretion that has already been exercised, and it is dealing with it on appeal. And the entry point is very narrow. Thank you, Justice Mulema.
Yes, Justice Mulema. I might need slightly more because I'm dealing with both counsel. You know, they say we learn every day. And I want to maybe apologize to Justice Ponen because I said you can't say you've lost because you've lost. And I've been proven wrong. Because that's exactly what Mr. Ngwaitobi has been doing. The entire argument, but all of it, is based on, I don't know how many, I was counting, I lost count, or how he has used the word abuse. Abuse. This is abuse and abuse and abuse. So he does exactly what I said you cannot do in cases of this kind, if you accept that they are meant to favor the loser. Of relying on the very judgment that is being appealed against as the basis for which you should give an 18-3. I mean, what on earth? Who would ever succeed in an 18-3 application if that absurd approach was to be taken? So if you take away the reliance on the very judgment that is being appealed against, Mr. Ngwaitobi has said nothing at all. Because he, without that, assume for a minute that I'm correct, that you cannot use the very abuse that has been alleged, which may be overturned on appeal one day, as your ground. If I assume for a second that I'm correct in that, then that's the end of everything that he has been saying. Because there's nothing else except that Mr. Zuma does not like Ms. Maughan, and she has insulted her, and what have you, and even these exaggerations about members of the family. I don't know who those members of the family are. Even the judgment says that members of the family, members in plural. If this was true, there would be no need to exaggerate. It's because it's false, so you have to exaggerate. The only evidence that is there is that there was a tweet which came from Mr. Zuma's daughter. That's it. But the judgment says members of Mr. Zuma's family, and it's among that counts Mr. Manyi as such a member of Mr. Zuma's family. That's how fallacious this whole business is. Then there are no so-called members. At best, it's one member, and even that member, Mr. Zuma dealt with in his answering affidavit. He says, I can't be held responsible for the tweeting or social media activities of a grown-up woman who happens to be my daughter. Surely. But it has to be exaggerated so that it is made to look all this scary stuff. So, I'm sorry for the pun. If you disabuse our mind of this abuse point, which is used as the scarecrow, then the whole argument falls flat. The second issue is that Mr. Ngqokaitobi says that we are sitting as a court of appeal, which is correct. When it comes to exceptional circumstances, he understands very well that your job is not to look at the exceptional circumstances, but to examine whether the court à quo looked at exceptional circumstances. And he's right. But suddenly, when his prospects of success, he forgets that theory of his. Now suddenly, you must look at the prospects of success. But the same rule applies to all the requirements. This court is not, and I cannot emphasize this point more, this court is not being called upon to examine the prospects of success afresh, so to speak. It is only merely called upon to adjudicate whether the court à quo, as Mr. Ngqokaitobi correctly points out when it comes to exceptional circumstances, dealt with that issue properly or not, number one. Number two, to understand this entire issue, one has, and I'm saying this because I said it in the morning, if we don't appreciate that there is a difference, which Mr. Ngqokaitobi appreciates when it suits him, but doesn't appreciate when it doesn't. There's a difference between 18.3 and 18.3 application and an 18.4 appeal. That, Justice Mulimelo, the Madam Justice President, presiding judge, is an explanation of what you were grappling with in respect of what was said in KNOOP. Once the difference between 18.3 and 18.4 is appreciated, that conundrum, what looks like a conundrum, disappears. Let me explain why. That's why there's this notion by Mr. Badlander that KNOOP somehow departed from Tlameza and AfriForum. There's no such thing. All those, actually, if anything, KNOOP affirmed those cases. The only issue that Justice Wallace said at the end of paragraph 50 is the following. And he talks about an appeal, not the application à quo. He says, the usual principle that an appeal court, yourselves here, decides the appeal on the record before the High Court cannot apply in those circumstances. That's self-evident. If you do not have the record as the appeal court, you cannot then, postulate on those issues. That was held in Tlameza, that was held in UFS, and that is correct on appeal. And then it says, if the language of section 18.4 is the appeal section, not the subsection, not the 18.3. If the language of section 4 confers a discretion, is is that a full discretion or a power combined with a duty to exercise that power on proof of the requirements for its exercise? These issues may warrant reconsideration of the approach in Justice Alliance on an appropriate occasion. This is not even that occasion, because here we are not dealing with the issue of prospects of success on appeal per se. We're dealing with whether the court accord in 18.3. So, to the extent Justice presiding was correct, that how can anybody suggest that Knoop departed from Mtlameza and UFS when Knoop says in so many words that there's a dictum that supports this approach, but in both cases in Mtlameza, the record, the main appeal was not before this court and so on. And it cites Justice Alliance explicitly, and at paragraph 48 it deals with the UFS court. So this is just obfuscation, deliberate obfuscation of what must happen in the court of call and in the appeal. So this is simple. Now we're told, no, Mr. Ngwatobe actually says, you cannot prosecute a journalist. So you must make a decision on this appeal, on this sentimental stuff about what is it, preservation of justice and what have you. No. This is a court of law. It's not a court of exaggeration and hyperbole. If it doesn't matter whether you are a journalist or the Pope, if you have not pleaded the requirements of law that are needed to establish your case, you must lose. It doesn't matter how sympathetic you could be, an orphan, whatever. If you have not pleaded the requirements of the law, how can you succeed in a court of law? Just out of sympathy.
But didn't he qualify that by alluding to the fact that in this instance, the law says for private prosecution to take place, a certificate must have been issued, and in this instance, it not been issued?
No. Well, that is absolutely wrong. That actually is taking the court for a fool. Of course, you must have a nolle prosequi certificate. What do we have here? You know, this kind of thing really. We have a situation, the facts are very clear, Madam President. In fact, if talking about the chilling effect, is the facts of this case. Contrary to what Mr. Badlander tells you about the so-called, when this fails, then Mr. Zuma brings another case, that's false. Because, in fact, that's what he says, or not him, Mr. Downer says under oath, which Mr. Badlander repeats in his heads, which is wrong. What actually happened is this, and I'm saying that because I was there. On the 21st and 22nd of September, there was a hearing of the Section 106(1)H. Ironically, these people who are telling us about Stalingrad will not tell you that that very hearing would not have happened if Mr. Zuma had not said, I'm waiving my right. He was in jail at that time. And in terms of the Criminal Procedure Act, he's entitled to be present in a criminal court. We all know that. Mr. Zuma, this very Mr. Zuma, who is so violent, delay, says, it's fine. You can continue with your Section 106(1)H in my absence. I'm waiving my right to be present. This is the Stalingrad master. And then the case happens. In that hearing, I say to Justice Kuhn, Justice Kuhn, we've been running with this case since the May of that year. But I say now, something else has just now happened. In August, which was the previous month, while Mr. Zuma was in jail, his military doctors sent a document which was marked confidential, it says. And that document was leaked deliberately by the prosecution to Ms. Maughan. And therefore, I'm asking for leave for you to allow us to bring that as another ground. Justice Koon, and I say to Justice Koon from the bar, admittedly, I say, on this we have instructions from Mr. Zuma to institute criminal proceedings. And I know it has not yet happened, but I'm telling you. Then Justice Koon says, not all these things, that the reason why Mr. Badlander started at paragraph 246 is because he wanted the court not to be aware of what Mr. Koon, Justice Koon, actually said. It is not true, it's false actually, to say Justice Koon rejected this issue about the disclosure of Mr. Zuma's information. Instead, Justice Koon actually said that you must go and lay a charge. Well, not in so many words. I'll read it out. Yes, this is what he says at 240 of his judgment. Not 246, let's start where it actually starts. He says, as the complaint was only made, in the previous paragraphs, he cites section 41.6 and so on. And he says, as the complaint was only made in argument, which by me, and I confess I did that. And then in reply, Mr. Downer did not have an opportunity to respond thereto. I accordingly also did not have the benefit of the issue having been fully dealt with in argument, and we are told that he actually dismissed it. And then he says, in those circumstances, I consider that it will be improper to consider the request of any such referral further in this judgment. Apart from that procedural difficulty, I have doubt whether the wide terms of section 41.6 are necessarily constitutional and or would necessarily find application on the facts of this matter. Prima facie, it would not, in my view, be unlawful for a prosecutor to deal with the inquiries from the press to ensure that the public is properly informed of the work of the NPA and the progress in investigations, which inevitably might result in the disclosure of information which came to his or her knowledge in the performance of his or her functions in terms of the NPA Act or any other law. I would have thought, he's speculating, that Section 41.6 would not, for example, prohibit a member of the NPA in response to inquiries from a journalist, which this was not, because here the whole interaction was initiated by Mr. Breitenbach, there was no inquiry from a journalist, to confirm or deny that a particular suspect might or might not be formally indicted on particular charges, or the assistance regarding particular investigation in another jurisdiction was being pursued. And then this is what he says, the showstopper. But these are simply ruminations without the benefit of having had considered argument. It is believed, if it is believed, that the provisions of Section 41.6 outlaws such conduct, then a formal charge in that regard can be pursued, where the proper application of Section 41.6 can be fully ventilated and its proper interpretation determined. That's all Justice Koon did. He didn't do all these things that he's being falsely accused of. He says, if you are aggrieved, I'm making my own ruminations. Is it constitutional? Remember, though, how important that is. Because here, none of these parties, including Ms. Maughan, challenges the constitutionality of Section 41.6. So this court has no option. It doesn't matter even for Justice Koon. We, as people talking in the street, might say, wouldn't this be a bit drastic if it was applied to a journalist? But until somebody takes it to court and challenges its constitutionality or say that there must be a journalist exemption or whatever, it must be applied as it is. What does it say, that section? It's very simple. It's being complicated by the other side. The section says you will be imprisoned for a period of up to 15 years. That's how seriously it is taken. If any person discloses information, forget this thing about confidentiality is a red herring. No, there's no need that it should be confidential. If you disclose any information to any other person, when that information was gained in your job as part of the prosecution without the permission of the NDPP, full stop. Why does the law put 15 years sentence to this, sometimes higher than even murder? Because the law wants to tell us that the integrity of the prosecution services must be such that a prosecutor should not just go around trying to get rounds in a tavern and say, oh, well, I'm prosecuting my Leonard, whatever, and in that case there's a, there's a photograph of this and that and the other. If they do that, they must go to jail for 15 years. This is not a small matter. And therefore, when the members of the prosecution disclose to Ms. Maughan such information in these circumstances, and it's not true that this is just about timing. No. And in fact, even if it was about timing, the timing is very simple. At 11:06, Mr. Breitenbach, or rather, Mr. Downer does his affidavit. At about 5, I might get the times wrong, towards 5 o'clock, Mr. Breitenbach, unprovoked, picks up the phone, calls Ms. Maughan, or WhatsApp, I'm not sure, but initiates the contact. Where are you? Are you in Maritzburg? She says, no. She said, no, you don't have to come because there's going to be a postponement and there's an affidavit that's going to be sent and all that. And then he says, please send it to me. Here's the thing that really it means people are being taken for fools here. Mr. Breitenbach says, I will give you the information provided you do not publish it until the document is filed. Why would he do that if now we're told, no, the document was actually already filed? That's just absolute nonsense. Because the deal of saying you may not publish this until it's filed means they knew that what they were doing is wrong. So they say, please hold on to, I'm giving you the information, but hold on to it. The filing then happens the following day on the 10th. And indeed, as primed, Mr. Downer, who's a participant in this thing, Mr. Downer is told by Mr. Breitenbach, please tell me when you file so that I can tell Ms. Maughan. He does exactly that. So it's like a bank robbery. The one points at the teller, the other one keeps the car, the other one is driving, the other one is checking whether the coast is clear. And then you tell us, no, the one who was checking whether the coast is clear is fine. Where's the actus reus, says Mr. Butler.
Yeah, I was going to ask you that.
The actus reus.
Where is the actus reus?
Yes, exactly.
Up to that point.
Thank you very much. The actus reus is here. As in the example I've just made of a collective bank robbery. Mr. Downer.
Now talk about Ms. Maughan, up to that point.
Yes.
Where is the actus reus for the
Ms. Maughan, that one is very simple. It is this. Firstly, for the purposes, just to cut time, Justice Ponan, you must postulate for now that Mr. Downer has done, and Mr. Breitenbach have done all the wrong stuff. So we're just checking whether Ms. Maughan is also in the net, so to speak. Well, Ms. Maughan's role in this is that she is the recipient of these proceeds of crime. There is a crime, for example, in our statute called receiving stolen property, knowing it to be stolen. I'm just using that as an example. So what you do in that crime, you punish the thief. That's the person who goes to break up at Woolworths or whatever. But you then punish the person who receives, the recipient and it might be that she might go to the criminal court and say, oh, well, I thought Mr. Breitenbach had the permission of the NDPP. Fine. Then she'll say that. But she cannot be acquitted through the back door and made to look like an angel when she received these proceeds of Mr. Zuma's medical information, people. You know, which one of us here would like their medical information to be put around to a journalist?
In her case, the mere receipt of the information constituted the act is raised for the purposes of a criminal offence.
Yes,
I'm just trying to get clarity. You don't have
No,
to
no.
but I'm just trying to have a sense as to
Yes.
exactly what it is we're talking about.
Okay, let me explain it like this, maybe. If someone steals my car, right, that person is guilty. That's the Downer-Breitenbach side of the thing. If someone else then takes the stolen car, that person may not be guilty of the same crime or in the same manner as the one who actually broke and did the thing. But I'm saying this is trite actually. In the criminal, in the scope of the criminal law, even in corruption, I think is another good example. We all say glibly, there's a corrupter and a corruptee. Of course, you must punish the corrupter, but you also punish the corruptee, which doesn't happen often in this country, because it's usually a private company that goes and tells a government person, please do this, and then we all punish the corrupter, which is fine. But we must also punish the corruptee. It's the same axis. If a journalist or an engineer, it's irrelevant that she's a journalist, whether it's an engineer or an accountant or whatever, or the person sitting in the tavern, in my example, once that person is a recipient, if I say to them, look here, I'm giving you this photograph, you must give it to your friends, or don't do anything with it if you like.
Let's see if I can assist you.
Yes.
Why I'm asking you the question.
Yes.
I initially understood that the complaint as against her was that she published
No, that's another red herring. That's actually the most irrelevant thing. There are two red herrings which you are fed with. One is the one of confidentiality. This case has got absolutely nothing to do with confidentiality. The second red herring is this thing about publication. It's got nothing to do with publication. The Section 41.6 is very clear. It says you may not give information. It says nothing about publication. I don't know where that came from.
That's why I asked the question. He talks about giving information. I was wondering how.
Yes, it's about giving and receiving. That's all I'm saying. I'm sorry, Justice Partner. Sorry, yes, that.
What is, and this is where you started to deal with this. My sister presiding asked you about the nolle prosequi.
Yes.
What is your submission as
Okay.
that is concerned?
Good. Thank you. I'm sorry. It's just that I just had this misrepresentation of what Kun Jay said. It just gets me here. No, the answer to that is this. For lawyers to talk like this is actually embarrassing, not especially here in the SCA, where we know about the end-domini, what we call the end-domini approach to interpretation. This is what happened, Justice Partner, and it's very simple. In January of 2022, the prosecution, the NPA, made a decision. That decision was, it's in writing. We decline to prosecute any person to do with this matter. Please mark those words. This is in January. In April, I'm sorry, no, it's not January, it's the 1st of April.
Let's just see if I can assist.
If you can just indulge me, please.
If I can assist, because this is what I'd like you to deal with. There was a first nolle prosequi certificate.
Of the 6th of June, yeah.
So, in relation to the first certificate, what is the submission? Is the submission that covered Ms. Maughan?
Yes,
Okay. In relation
to the second one.
Then, of course, if the first certificate covered Ms. Maughan, it's not necessary to consider the second certificate.
No. That's not true. I'm sorry, that's not correct. And that's why I was taking you through this journey. If you indulge me, please. Yeah. I'm saying, Justice Ponan, they take a decision. This is very important. They take a decision on the 1st of April. We will not prosecute any person. That's what they say. But in June, on the 6th of June, and then they start saying, no, you're not entitled to the nolle prosequi. We write a letter, we threaten them, we say, we're going to give you, make an application to compel you. Then they give in. In June, they then give us the certificate. Deceptively narrowed certificate. They are sitting with a decision. We didn't know this by that stage. We only knew it this year when we got a record in the Ramaphosa matter. They deceptively narrowed that certificate to refer to Mr. Downer. Deceptively. I say that advisedly. Then, of course, Ms. Maughan says, aha, I'm not mentioned in the certificate. She writes to us and says, you must withdraw the charges against me, what have you. I'm not in the certificate. This is in September now, after the 5th or 6th. Then we write to the NPA. We say, NPA, imagine this, we didn't even know the truth of that, but we suspected that there's some shenanigans. We say, NPA, you remember when we did the complaint to the police, we said this complaint covers a whole lot of people who may be directly or indirectly involved, the usual legal stuff. So please tell us, Ms. Maughan has now taken this point. We want you to tell us is she included or not included in the June certificate, failing which we will go to court. They give in. They first say, no, she's not included. We say, okay, fine, then we will compel you. Then I think they had some meeting. Then they say, okay, we'll give it to you. On the 21st of November, they then gave us the new certificate, the second one. It now says what the first one should have said. It says, I Elaine Zungu, NDPP, I decline to prosecute any person in connection with this matter. Mr. Nguraitobi then comes here and says, Ms. Maughan is not mentioned. Of course she's not mentioned, but lawyers are supposed to interpret document. What does it mean? What did they mean when they said, I decline to prosecute any person? The exercise is very simple. Is Ms. Maughan or myself or anyone else, because if it says any person, it could mean all the 60 million inhabitants of South Africa. Obviously, it didn't mean that. It says any person in connection with this matter, and that narrowed it down to 5 or 6 people or whatever. And it is at that point, Justice Ponen, that we then say the interpretation, in fact, it's not even an interpretation. Let me, please allow me to do this. Let me take you to the application for leave to appeal, just to show you the kind of thing we're dealing with here. It's actually, I have no words for it. But these same people, I'll just paraphrase, you'll find the application for leave to appeal at 459. And the attachments there to start at, 472. This is the kind of people who are dealing with here. In the Ramaphosa matter, which happens in January, about the same no lesser prosecution certificate, by the way. Because that one was a review, we then say we want a record. We get the record. The record makes it clear that in April already, before the first certificate, the decision that was taken was about any person in connection with the matter, which included Ms. Maughan already, before the deceptive certificate. But you don't have to believe me. You must believe what the author of the certificate says. You'll find that at 477. Paragraph 6.4. She says in an affidavit on the oath in the Ramaphosa matter, at the relevant times, the first respondent, whether in person or through his attorneys, first respondent there is Mr. Ramaphosa, of record from time to time, it's Mr. Zuma, the first respondent. Mr. Ramaphosa was the applicant. So it says, at all relevant times, Mr. Zuma, whether in person or through his attorneys of record from time to time, only identified 2 suspects, Advocate Billy Downer and Karyn Maughan. No mention is made of the applicant as a suspect. That's what the NPA tells us, right? And then, but we're told, no, we must forget all that. And then the next, look at 487, paragraph 23.3. This is now from the heads of argument of the SC who represented them. At 487, madam, 487. Paragraph 23.4. Their counsel now relying on the same thing says, in SAPS Pietermaritzburg case 309-10-21, that's Mr. Zuma's complaint to the police, only 3 possible suspects are identified: Advocate Billy Downer, Karyn Maughan, and possibly Advocate Breitenbach. But this court must now fall for these cheap tricks. The same people who are telling you that no, all these things that you have been told here this afternoon, she's not named, are saying that the court must close its eyes to the fact that the author of the document says that she was part of it, and the nolle prosecution. In which world can that ever be done? And by the way, let me say this in fairness to my learned friends, because they don't have another chance to come back. That part that I've read, just to be frank with the court, belongs to a part of the application for leave to appeal, where we say this evidence that I've just referred to is going to be, it will form part of even the petition to show that the acquittal, as I call it, of Ms. Maughan by the civil court was wrong. Now, we said that because at that stage we had not done the applications for leave to appeal. I can tell you now, I'm not testifying from the bar, that since then the application for leave has been, as Justice Ponan pointed out, has been dismissed. And what is, or at least our instructions now, is that when we do, because we don't want to waste the time of this court, and I know it's been done before, those 2 appeals will, at least there'll be an application to consolidate them. Let me not say they'll be consolidated, because that's not in my power. But there'll be an application to consolidate those applications. So there will be no need anymore to make an application to introduce this evidence as so-called new evidence, because it will be part of the whole thing. So think of it like this. One day, this court will be sitting with a version that says Ms. Maughan was not mentioned from the state, and then another version from the state that says Ms. Maughan is mentioned. Obviously, she's one of the people who are mentioned. That's the kind of mambo jumbo that the courts are expected to believe. Now, you might ask yourself this. Take yourself a bit from this. Take a deep breath and say, if they are so innocent, why are they here? Why didn't they laugh this thing off and say, okay, this prosecution, where's the actus reus? The prosecution would be done by now. But no, they are more wasting money. They accuse us of Stalingrad. They are wasting money to avoid their day in court because they know that there are no answers to these charges. And that is why they're here. Because they should be saying one of 2 things. Either we'll call your bluff and we'll remove Mr. Downer from the prosecution. And then, where will you get your Stalingrad now? And then you have the prosecution. Or they should say, okay, bring it on. This thing is so frivolous that we will be acquitted even by a magistrate. No, they are avoiding, they are doing what Wallace J.A. said should not be done in the Moyo case, of allowing well-resourced accused persons to use the mechanisms in the civil courts to achieve what should be dealt with in the criminal courts. That's what's wrong with this picture. And then they tell you that there are no prospects of success. This court is going to turn against its own judgment in Moyo, where it said you must not go to the civil court. If you have a problem, do what Mr. Zuma did before Judge Kuhn. Raise the issue. Do what Mr. Zuma is doing now before Judge Treli. Raise that issue in the criminal court. Mr. Zuma has not, the Stalingrad king is taking his objection about Mr. Downer to the criminal court to avoid delays. The anti-Stalingrad crowd is leaving the criminal court go to the civil court, go via Paris and whatever, instead of taking the N1. That's the what is this? We cannot even, the people who are guilty of Stalingrad here, if there's anyone, it is them. Because they should have their so-called day in court and let it go. Secondly, and and this shows the futility point. I like Mr. Badlander used that term. It shows the futility of this thing. What does it matter? And we said this to the court again. If you grant or not grant that relief, because of two reasons. I've already mentioned in the morning the first reason, that the delays are caused by the recusal application, not by this. This has nothing to do with either a delay or non-delay. The criminal case of Mr. Zuma will only take place once the removal application has been finalized, or once sanity prevails and Mr. Downer recuses himself, whichever happens first. But here's the thing. Let's assume that this execution order is granted. How does that remove the perception of bias on the part of Mr. Zuma? How? Because Mr. Downer will still be susceptible to the appeal process, which may find that he must be privately prosecuted. So on that score alone, he's disqualified from prosecuting Mr. Zuma. So what you do here or don't do is completely irrelevant to that question. Because even if forget about all this, let's assume Mr. Zuma goes to the removal court and says, I am telling you now, court, that Mr. Downer his matter is in the SCA. That SCA or the Constitutional Court may one day make him an accused in the private prosecution. And therefore, I don't want to be prosecuted by him because he bears a grudge against me merely on the possibility that he will be prosecuted. So this is an absolute waste of the court's time. I'm sorry. To wrap up, yes. Okay, thank you. Let me just then go to... And then we're told that Mr. Zuma must be punished for exercising his right of automatic appeal, which the Act gives. And I agree with Mr. Badlander with respect on the issue of the two, on the point postulated by Justice Ponan, that the intention of the legislature was obviously to do away with the application for leave to appeal and deal with the issue of appealability. But here is what our Mr. Nkaitobi tells us. No, you are not supposed to worry about the reasons. But how can that be? And Justice Ponan says, well, that's the trite proposition that what you appeal against is the order. No. This is a different kettle of fish. That is true in a normal appeal. But how can it be true in an appeal where the legislature, Parliament in Cape Town, says, if a court orders otherwise as contemplated in subsection 1, the court must immediately record its reasons for doing so, and the aggrieved party has an automatic right of appeal. That means, why? What's the purpose of section 18.4.1? If that is true, what Mr. Nkaitobi is saying, then it would be purposeless. The reason why the legislature legislates that you can never give, in an 18.3, you can't do what courts sometimes do, which is just to give you an order and then you can deal with it. You can even appeal on it. It says, no, you can't do it. By legislative decree, you must give reasons. Why? It is because every court, and Justice Mulimela was quite correct, every court that has dealt with these matters, Tlameza, UFS, KNOB, has gone on to scrutinize, as it should, the reasons. In Tlameza, the issue was whether the remarks of Matojane J, as it then was, in an earlier case should be taken into account. And the court grappled with this and came to the conclusion that Matojane J's remarks should be taken into account, and therefore gave his judgment. In Free State versus AfriForum, the AfriForum was saying African students are being prejudiced because now there's an English medium of instruction and all that, and the world is going to fall down, as Justice Mutle was saying. It was a question of statistics. So is it 20 years or is it not 20 years? I mean, it's that simple. So they came to court and came with hyperbolic statement. They said hundreds and thousands of students will be prejudiced. The court said, no, let's look at the facts. And it showed that there were only 386 students and 0 of the entrants. And then the court said, because of these reasons, we are rejecting it. In Knoop, the same thing happened. In Knoop, it was the Gupta, Mrs. Gupta, and the business rescue practitioners. And that is, and the court granted, as I said earlier, even orders dealing with now how the BRPs are supposed to. And Justice Wallace went into the reasons and said, no, you can't include this is wrong, and said something important here. Even if the order was to prevent dishonest, I can't remember the actual, it's in our heads. And it goes to this abuse story. In Knoop, the court said, even if you are dealing with dishonest or abusive people, you still cannot grant exceptionality on that basis. The exceptionality has to be scrutinized carefully by this court, and that is why the abuse theory is completely wrong. Because what it says is that forget about the 20 years that is distorted. Forget about that the Stalingrad thing is just made up. Forget about the fact that there might be another prosecutor. You must just say it's an abuse. But the abuse comes from those facts. It comes from the 20-year theory. It comes from the Stalingrad theory. It comes from the indispensability of Mr. Downer. So if you take away the substructure of the abuse finding, how can it survive? And if the abuse finding does not survive, nothing they've said will survive. Because both my learned friends have pegged their entire case on this finding, on this abuse finding. Apart from the fact that, 2 minutes please, Justice Parliament. Apart from the fact that when it comes to the I want to end by going back to the prospects of success issue. You see, the task of this court is actually much simpler than meets the eye. This court must decide now whether the approach taken in Bila, which introduces what it calls the fourth requirement and defines where the onus lies, is correct or not. If it is, then what Mr. Badlander, I'm sorry, I have to do this. Mr. Badlander tells you, I can't go now, I'll just tell you. At paragraph 53 of his founding affidavit, he says, oh no, but we mention application for leave to appeal there. Well, they are both wrong. Firstly, I've said, in that paragraph 53, it says, on the, I'm sorry, I have to. It says, I submit, this is page 23, I submit that given these findings, after traversing the findings of the full court and the findings I summarize in paragraph 16, nothing to do with the application for leave to appeal. Remember, they don't even have it at that stage. Mr. Zuma's application for leave to appeal has no prospects of success. That's not the test. The test is not about application for leave to appeal. The test is prospect of success in the appeal itself. Right? That's what it is. I see there's some giggling behind me. But that giggling is misplaced because the test is very clear. It says prospects of success on appeal. And that's a completely different thing to prospects of success on the application for leave to appeal. Why? Because it goes back to what Justice Ponen was grappling with correctly about whether is the fact that the application for leave to appeal has now been dismissed relevant or not. And I've submitted why I say it is not. So there's a big distinction. But forget about that. Let's be kind. Let's say prospects in application for leave to appeal also might mean application in the appeal itself, which it doesn't. But then what? Where do you actually now establish the owners? Let's say you've pleaded it now, to be kind. And then what? Not even where. How can you say I've discharged the owners to establish prospects of success as a sangoma without seeing the application for leave to appeal, without considering the 12 grounds that are raised there? I don't have time now. And this court, the court accord, says if the prospects of success are only based on subsidiarity, then they are slim. How can that court even make that statement when at that stage it is armed with the actual application for leave to appeal, which raises Plascon Evans, which raises the fact that, which raises Moyo, which raises stare decisis, which raises how can that court say if it's only confined to subsidiarity when it knows that it's not confined to subsidiarity? That is wrong. So the Moyo, what they do, all of them, is to actively stay away from the case of Mukhesi. You'll see in our list of cases, the case of Mukhesi. That's the case in which Mr. Ace Magashule and his co-accused is the only case that's post-Moyo, by the way. All these other cases they're talking about 1950s and what. But post-Moyo, Mr. Ace Magashule and his co-accused went to court and said, these charges, all these things, they're politically motivated, it's an abuse, what have you. The court said in Mukhesi, we can't help you, sorry. Because the SCA said in Moyo that why must issues that are germane to criminal proceedings be resolved in civil proceedings? And because to do that is Stalingrad, and it's a form of delay, said Wallace J.A. And that application was dismissed. But they want to have a different outcome here. Why? Because there's one law for Mr. Zuma, and there should be another law for other people. The standard that was set in the Mukhesi case is what should have been applied in the Kotako. I know those issues will be dealt with in the appeal itself, but I'm simply saying, even at face value, the prospects of success in this matter are overwhelmingly in favor of Mr. Zuma, because if the case does not pass the first base of jurisdiction, or the Moyo, let's call it, forget about these labels of subsidiarity and whatnot. Let's say the Moyo tint test. Moyo and tint, the following rule was established. Courts should not countenance civil applications that are brought in the civil court regarding criminal matters, unless if it is in the interest of justice to do so. I can assure you, as I'm standing here as an officer of this court, there is nowhere where these applicants or respondents say that we must not be judged like in the Mukhesi case because these are the interests of justice and what have you. So the general rule applies, as we know in law, which is that thing should not even have passed the first stage. Stare decisis, I don't even want to go there. All the cases, Solomon, Belichana, that they rely on, they say the exact opposite of what they say. Solomon says that if the only thing you are bringing to court is the ulterior purpose to harass the other person, then obviously it's an abuse of court. But this court knows that this court said in Zuma versus DPP in 2009, I think it was Haram's JA, and it has now been reaffirmed in Redel recently, that it does not matter that you may have a so-called ulterior motive if you also have the intention to get a conviction. Mr. Zuma goes for pages and pages and pages in his answering affidavit saying, I am not doing this to punish anyone, I just want justice because my confidential information was taken away. Now, this court said, if you have, unlike what Mr. Ngugai Toby said, you do not only prosecute people that you love, or you prosecute all those people for which you don't have a feeling of retaliation. If somebody rapes my child, I'm going to have animosity against them. The fact that I have such animosity against them does not mean I must not go and lay charges. I must be disqualified because I also hate them. Yes, I do. Because they've broken into my house, stolen my car, or whatever. But how can that be a disqualifying factor? That's what Aram's JA was saying. Your ulterior motive, for as long as it is what Mr. Bradlander called mixed motives. So as long as you can, and there is no basis upon which this court or the court can say Mr. Zuma's version on the Plascon-Evans rule, where he says, I want justice, I want a conviction. On what basis can it be said that's far-fetched and it must be rejected? Yes, no, yes, I accept. No, you did. You gave me an indulgence. Let me round off then, Justice. I just want to say that if you look at this, I go back to where we started in the morning. My humble submission is that this matter resolved itself completely on the issue of prospects of success on the Bila rule. But even if I'm wrong on that, I say that the exceptionality is contrived, and also Mr. Ngugai asked us, where's the harm to Mr. Zuma? How can you say that? How can it be harmful to Mr. Downer that there's a delay in the criminal prosecution, but it's not harmful to Mr. Zuma that there's a delay in his private prosecution? Which law works like that? The same delay in the prosecution is harmful to Mr. Downer, but when it comes to Mr. Zuma, it's not harmful. Please. As a court, please. Thank you, ma'am. As a court, please. We're indebted to the court. Thank you. Okay.